so you can do this instead. Okay. So either way, you're either done or we'll have representation. Okay, just to need to represent. We'll stick on the case until you return going. That's what I have to go.
All right, Ms. Rivers, are you ready? Do we still missing one? Everyone's here. Okay, let's get on the record. In State versus Reynolds, it is Wednesday, the 6th, a little after 9 a.m. I'm going to explain this to the jurors, but if you all smell what smells like natural gas, there's a gas leak, not in the building. It's a few blocks away, but that's what we're smelling here. Everything is safe in the building.
In the hallway, I was like.
Yeah, it is something that is several blocks away outside the building that's being addressed, but all signs. Hold that thought. Okay, everything's fine in the building. This just in from the colonel. So what we've got now, we have Mr. Reynolds and his lawyer in court, Mr. Jordan for the state, and all that remains before the jurors begin their deliberations is for me to charge them. I am prepared to do that. Mr. Jordan, anything we need to talk about before we bring the jury in?
No, Your Honor.
Okay, Mr. Shepard?
No, Your Honor.
Can we bring them in, please?
All right, jurors. I'll do the president count for.
Good morning.
Morning.
Welcome back. It's Wednesday. Two things. First, you may smell natural gas. There is a gas leak. It is not in this building. It is several blocks away. And we just received the all clear from the lieutenant colonel who's responsible for building security that there's nothing wrong with us being in this building now. If that changes, Deputy Gordon, he gets live broadcasts over his shoulder radio and will react accordingly. But for now, it's better to be here than outside towards the direction of this leak, which is, I think it's sort of at the intersection of MLK and maybe Washington. It's over by the Capitol and the Sloppy Floyd buildings. But there are folks who are dealing with that. It is not in the building, several blocks away. That's number one. Number two, I will talk with the lawyers about this request for the PowerPoints. If you don't get them, it's because it's not appropriate for you to have them. If you do get them, it's because the lawyer said great. And I think that it's legally appropriate. I'm going to share with you now the law that you must apply to the facts as you find them to be. A few things about the jury charge. I will be reading it to you from this document. And I'll read it more or less verbatim because it's the law and I shouldn't extemporize. I may, in a few instances, to try to explain a term or to give an example, but I'm mostly going word for word what's in here. What's in here, this document will be with you during your deliberation. So you're free to take notes, but this document you will have to look over should you want to. While I'm reading, it will also be up on these screens. Some folks do better to see the words while someone is saying the words. And you, like I said, you're free to take notes, but you'll have this document while I'm reading, it'll be on the screen. There are a few concepts that I am constrained in defining by either the statute or higher court decisions. And so I may from time to time use terms that strike you as fussy, who talks that way. For example, you're going to hear me talk about an abandoned and malignant heart. I don't talk that way when I'm talking to my kids, but that is a phrase that judges are required to use when instructing jurors about one aspect of the crime of murder. When I'm able, I will try to define those terms. If I don't give you a definition, you ascribe to those terms the definition that you think those terms ought to have. But in general, I try to make the jury charge accessible. It's not particularly helpful to throw words at you and you're like, I don't know how to use these words. So apologies in advance that either the legislature or higher courts have said you have to explain certain things in certain ways. With that, let's get started. If I can get this to work. There we go. A grand jury has, let's make that smaller, indicted the defendant for murder, felony murder, cruelty to children, aggravated assault, and aggravated battery. The defendant has entered a plea of not guilty to these charges. Neither the indictment, which you will have during your deliberations, it's this, nor the plea of not guilty is evidence. The defendant is presumed innocent. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of each crime charged. I'll be giving you those elements in a little bit. There is no burden of proof upon the defendant, and the burden never shifts to him. If a defense is raised by the evidence, the burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to a mathematical certainty, this 100% guilt. That's not their burden. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. That's you all. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given, and that reason arises from your consideration of the evidence, lack of evidence, or conflicts in the evidence. If, after considering the evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant grave suspicion of the crimes charged or merely raises speculation about his guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law. That's what we're doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence presented. You must then apply the law I'm giving you to the facts that you find to see if the state met its burden. You must decide this case based only on the evidence presented during trial. And that evidence consists of the witness testimony you've received and the exhibits that have been admitted. Evidence does not include the indictment or plea of not guilty, anything said by me or the lawyers to include their opening and closing remarks, nor any questions posed. The evidence you consider may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact. This would be an eyewitness. I saw the car run the red light and hit the pedestrian. Eyewitness. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact. By inference, if three people walk through this door in 5 minutes, each with an umbrella, and they're shaking water off them, you could infer that it's raining outside. You can't tell because we don't have any windows here. I guess you could go in your jury room. But those people who are wet and they've got umbrellas would be circumstantial evidence that it's raining outside. There's no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. In doing this, you must determine the credibility of witnesses. In deciding credibility, you may consider all the evidence you've received, the witness's manner of testifying, the witness's basis for knowing the things about which they testified, the probability or improbability of their testimony, and their interest or lack of interest in the outcome of this case. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You heard from several expert witnesses. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. The testimony of an expert, like that of all witnesses, should be given only the weight and credit you believe it should receive. A defendant who has no burden to prove anything is not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. Statements the defendant allegedly made have been admitted at this trial. Before you may consider these statements as evidence for any purpose, you must determine whether the statements were voluntary. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, the use of violence, fear of injury, or any suggestions of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. The burden is upon the state to establish that the defendant's statements were voluntary. If you find that any statement of his was not voluntary, you may not consider it for any purpose. The testimony of a single witness, if you believe it, is sufficient to establish a fact. Corroboration of a witness is generally not required, provided you find the evidence to be sufficient. There is an exception to that, though. A defendant's out-of-court statement that is unsupported by other evidence is not sufficient to justify a conviction, even if you believe that unsupported statement. The law does not fix the amount of supporting evidence necessary for you to find that the statement is corroborated. You must determine whether other evidence sufficiently supports a defendant's statement to justify a conviction. That supporting evidence, if any, must be proven by the state beyond a reasonable doubt. Sometimes evidence is admitted for a limited purpose. You may consider this evidence solely for the purpose for which the evidence has been admitted and not for any other purpose. Evidence of prior difficulties between the defendant and the deceased has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the deceased. Whether this evidence illustrates such matters is for you to determine, but you are not to consider that evidence for any other purpose. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for this purpose. It is not necessary that the defendant show that another person committed the crimes. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but means simply the intent to do the thing that turns out to be illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find such intent, or the absence of it, from your consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. You may not find a defendant who was merely present at the scene of a crime at the time it occurred guilty of the crime unless the evidence shows, beyond a reasonable doubt, that the defendant committed the crime, helped others to do so, or otherwise participated in the criminal activity. Venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Here are the elements of murder. For murder, the state must prove that the defendant, number one, caused the death of another person, two, unlawfully, and three, with malice aforethought. The killing must have been done with malice for it to be murder. Malice, as the term is used here, in the context of murder, does not necessarily mean ill will or hatred. It is simply the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another. You may also find malice where there does not appear to be significant provocation and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, that is, with unlawful intent, it is murder regardless of how briefly that malicious intent existed. No specific length of time is required for malice or intent to arise in the defendant's mind. That malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice, that unlawful intent to kill, was in the defendant's mind at the time of the act that killed, and it moved him to do it, that is enough for the killing to be murder. Proof of motive is not essential to the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the time of the killing. Felony murder. For felony murder, the state must prove two things: that the defendant, number one, caused the death of another person, two, by committing a felony. With felony murder, the state does not have to show that the defendant acted with malice, that is, this unlawful intent to kill. It's the intent to commit the felony. Aggravated assault, aggravated battery, and cruelty to children are all felonies. You may find the defendant guilty of felony murder if you believe that he caused the death of another by committing the felony of aggravated assault, aggravated battery, or cruelty to children, regardless of whether he intended the death to occur. There must, however, be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when that death ultimately occurred. Aggravated assault. A person commits an assault when he attempts to commit a violent injury to another. A person commits an aggravated assault when he assaults another with an object which, when used offensively against a person, is likely to result in serious bodily injury. The state is not required to identify the exact object used in an assault if the circumstances of the case do not allow for such specificity. Aggravated battery. For aggravated battery, the state must prove that a defendant, one, maliciously caused bodily harm to another person, two, by depriving that person of a part of her body, or by rendering a part of that person's body useless. In deciding whether the defendant acted maliciously, that's the term from element number one, understand that malice, again, is not ill will or hatred. It means simply the intent to cause the bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that harm may result. Cruelty to children in the first degree. For that crime, the state must prove that the defendant, 1, maliciously caused, 2, cruel or excessive, 3, physical pain, 4, to a child under age 18. And again, in deciding whether the defendant acted maliciously, remember that malice is not ill will or hatred. Here it means simply the intent to cause the pain without justification or excuse. Also means willfully doing an act while aware of a strong likelihood that pain may result. When the language in an indictment alleges more than one manner by which the defendant committed the crime, the evidence is sufficient to convict if the state proves, beyond a reasonable doubt, that the crime was committed in any one of the separate ways listed in the indictment. That is, the word "and" in the indictment can be read as "or." In the indictment, it refers to the defendant allegedly causing cruel and excessive pain. But those are two different ways of committing the crime of cruelty to children. And the law is, even though it says "and" in the indictment, you would read that as an "or," and the state need prove only that the pain was cruel or excessive. They can prove both, but "and" means "or" in the law in this context. Ladies and gentlemen, you should consider each count in this indictment individually. The defendant may be found guilty of some, all, or none of these charges. If, after considering the evidence together with this charge, which is almost done, you should unanimously find beyond a reasonable doubt that the defendant did commit here in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. In that event, the form of your verdict would be, "We, the jury, find the defendant guilty," and you would check that option on the verdict form for that offense. This is the verdict form that you will have. There is an entry for every count, and for each count, it says, "We find the defendant," and there's guilty and not guilty. If you reach a unanimous verdict, you check the verdict you reached, guilty, not guilty. There's not a third option other than we don't reach a verdict. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, "We, the jury, find the defendant not guilty." And you would check that option on that verdict form for that offense. Whatever your verdict is for a particular count, it must be unanimous. Your verdict must also be in writing, this form, and signed on the second page by your foreperson and dated. Didn't switch the slide, but those are the words I just read. By no ruling or comment that I have made during trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence according to the laws given to you in this charge. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a fellow juror is making decisions based on improper considerations of race, gender, or sexual orientation. Ladies and gentlemen, you are the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign this verdict, to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with everyone and a careful consideration of the evidence. Unsurprisingly, during your deliberations, you must not communicate with anyone outside your group about the case, nor may you conduct any research. You have all the evidence in this case. It would be improper to supplement it with any outside information. And to assist you in complying with this important instruction, Deputy Gordon will be collecting all your electronic devices while you deliberate: computers, cell phones, Apple Watches, all that kind of stuff. We'll give it back to you when you're done, but while you're deliberating, you will not have that with you. Going forward, should you need to communicate with me for any reason, it must be in writing. Upon receipt of your question or note, I will confer with counsel and share with you whatever response I am allowed by law to give. And that last proviso is important. You may have a great question, and my answer may have to be by law. You need to sort that out yourselves. And that's not me being difficult, but just as an example, and I talked about this when we started the trial. Hey, could we have a transcript of witness X's testimony? Nope. You're going to have to rely on your collective recollection as to what that person said when that person testified. We do have the ability to replay audio and video. So if there's a video that you watch that you want to see again, or an audio that you heard that you want to listen to again, that can happen. You just send out a note saying, we want to listen to X or watch Y. We'll bring you out here, pop it up on the screen, and you may even be able to say, well, we don't need to watch the whole thing. We want this little segment, and we will cue it up to whatever you need and handle it that way. Those are my instructions to you. In a moment, I'm going to ask you all to retire to the jury room. Deputy Gordon will bring you the physical evidence that's going back with the jury, the verdict form, the jury charge I just read to you, and the indictment, and then you will begin your deliberations. Whenever you want to take a break, you can, but if one person steps out of the jury room, you need to stop deliberating. You can only deliberate when you're all there. So if someone says, I got to walk down the hallway, honor that request, but don't keep talking about the case. Wait till he or she comes back. You can break for lunch whenever you want. If you're still going at lunchtime, we just need to know when that is so we can coordinate. The lawyers need to be nearby because whenever you have a question, I need to run it by them. I may impose a lunch break on you if it gets to be a certain hour, just so we have that happen. But otherwise, we'll proceed according to your schedule. I need 2 jurors to stay in the jury box while the rest of you go back. Mr. Hansard and Mr. Lee, you 2 should stay put. The other 12 of you should go to the jury room. You can start figuring out who your foreperson is going to be. And once we get you the evidence, you can begin your deliberations.
All right. You can take a seat. You 2 are our alternate jurors. We don't tell you that in advance because we want everyone to be equally focused as opposed to think, I don't need to worry about this. For today, I'm going to keep you both here. If for some reason deliberations spill over into tomorrow, we can talk about how quickly you could get down here if we need one of you to replace a juror that has to be excused for any reason. But since you're here already, should we run into a situation where we need to excuse a juror, one of you would be pressed into service. The jury necessarily restarts its deliberations when you get back there, so you're not coming in behind. It's a complete refresh should that happen. The 2 of you, is there a? Yes. There is. So there's an extra jury room over there. The 2 of you will be there. You get to keep your electronic devices. Just don't do any outside research or engage with folks about the case because you're still serving as a juror. And if we need to deploy one or both of you in there, we need you not to have been tainted by, well, now I'm going to look up this thing I've had a burning question about. And don't talk about the case between the 2 of you. Talk about anything else. Sleep, do whatever you want. And when your colleagues break for lunch, we'll let you know because that'll be your lunch break as well. And in fact, you can go to lunch with them because they can't talk about the case during their lunch break. We promise we won't forget about you. We'll keep you posted as the day is progressing. Okay, sir.
Would it be, I have a briefcase in my car with work. Would it be possible to get it? It's in the garage across the street and bring it into the room?
Definitely will be. Why don't you get your stuff out of the jury room? If you've got anything in the jury room, get situated so you know where you are. And then just let Deputy Gordon know you're going to your car and you're coming back. Okay. Then yeah, bring your work in and do what you need to do in the jury room.
Promise.
Okay, good. All right. Anything else?
All right, so you get your stuff out of the jury room, we'll get you in there. Thank you. Mr. Jordan, any exceptions to the charge as it was given?
None from the state, Your Honor.
Mr. Shepherd?
None from the defense.
All right. I have your numbers, so you don't need to stay glued to the table, but don't be more than a couple minutes away should something come up. I think we agreed yesterday, Mr. Shepherd wisely flagged it, what exhibits are going back with the jury and which aren't. Hopefully they're still segregated in that way. And I will add the verdict form, the indictment, and the jury charge to that pile, and the jury will be on their way. Anything else, Mr. Jordan?
No, Your Honor.
Mr. Shepherd?
I'm probably just gonna sit right here,
Great.
unless I have to go to the bathroom or maybe get something to drink.
Those are all fine. Those are nearby. So that you may do.
Are you gonna let us know when the jury goes to lunch?
Yes.
So I can coincide my lunch?
Very much so.
That'd be great.
Yes. There were only 24. Oh,
And I don't see the white tub. I'm assuming somebody has the white tub. Oh, well, I can't see through wood, like Superman can't see through iron or lead or whatever it was. Yes, there it is. Good. So we should have two piles. Lauren and I went through and segregated and put the stuff that goes back in the white tub, and everything else is in a pile with the court. Okay.
all right. Are you swinging around to get the bin?
I'm gonna get,
Oh, to collect the electronics? Okay. Did I give you, can you put? So what's in there is just what's going out. Great. That goes in there as well. Thanks.
You sit there and you go sit in the hallway. Yeah, why don't you, represent your phone, in case I have to call you. Don't say, I have to call you, get you back. It's like, I'll get call me, but I'm not like the phone. I stay close. So are you, is this your only responsibility today?
Today.
I saw them go back for 18.
Hey, I might creep over there.
Oh, we're gonna get, can we get this on the record? Mr. Reynolds, stay here for a sec, please. All right, we're still on the record. I forgot. One of the jurors handed Deputy Gordon a card that says, would it be possible for the jury to have a copy of both PowerPoints that the lawyers used in their closing arguments, realizing that they are not evidence?
Oh. No.
Okay. It only took one no. I'm just letting you know that the jurors asked that.
I don't want them getting my PowerPoint either, but they definitely don't get the states.
Okay.
Or the defenses.
Agreed.
All right.
I've never heard that question before.
Me neither.
I might start putting stuff in my PowerPoint now, thinking, this might get back with the jury.
There you go.
I didn't.
Yeah, you can go
I
ahead.
don't want to do that, but that's a clear no.
I remember, I thought that they were talking about one of these lessons,
You guys are going home.
so.
They did the taxes or in the button. But definitely not.
Definitely not Carlos.
Definitely not the state's open.
Yeah, so this is it today. I'll be back
So what you got tomorrow?
tomorrow. Final plea and final judgment. I mean, it's a very strange case. It's a, essentially, you wouldn't call it much as a housing case, but the father to hear supporting a child and to keep him in the hospital. You're not sure about it. The child is in custody. Yes, so he's not gonna be available, but I think we could just go to the doctors, that's the problem. Doesn't necessarily, we didn't necessarily have.
You might be looking at it too. What's-
I don't think that he, I think that,
That's the whole thing about poisoning is you don't know what's happening. It's not like, oh, I'll put some poison in your cereal. Here you go.
and it's like 2,000 pages of medical records, and it doesn't come until age 12. It's far down there. Hopefully we can take it. Put that on the top cuts. And I have Schwall, I have Murray, Schwall. Templates with this case, but not too similar. That was extremely young in the case. Very included on her head, mental health issues. And the child was embarrassed and also had blood for his family, brings the child was killing him at 6 weeks old.
These are very difficult, not just for the state, but for the defense. Living next to a child killer for 6 days now. Stuff. If he's wanting to shake my hand, I don't want to touch it, but I don't want to touch that either. Just look what it did.
We offered her 10 days on for a long time.
Involuntary. It was no sometimes in the streets. I can't really take that. Not got out 2 or 3 murders this year. One with one.
Yeah.
One with someone with Christina. And I believe there was one with Jasmine. And I just don't get it. But yeah, I didn't want to, he keeps wanting to shake my hand. I'm like, I'm gonna shake that. That makes sense.
It's tough. I always want to be cordial with people. Some of the cases. It's rough.
I remember one time I was in state prison, reads one, goes to the from the child. Everyone was just tiny little room. It was great. It was after class, it was about 30 feet, sweaty and a little, backwoods mustache, breathing and breathing. I'm like, I don't want that air going in my lungs.
I don't have that.
So he was a horrible, 2 daughters, and he was getting after them from the time they were like 3 or 4. And everything he could find around the house, sledgehammer, candlestick, back part of a light bulb that he had, the handle of a screwdriver. Anything he could find was going in both places. And the scar tissue, But it has a weird ending, so I'm going to tell you the weird ending. So he keeps wanting his trial transfer. I keep saying, I'm not going to mail that. I do not want to mail your trial transfer.
Yeah.
Because the other news might get it. I think it's a farm.
For that.
Yeah, the state bar says he wants his transcript, you have to mail it to him. This was late November that I get the order from the state office. I say, okay, it's the beginning of December, I'm getting this trial transcript. Like New Year's Eve, the other inmates murdered. Now, I can't say if there was any connection
Right.
between the two. If I was in the room
Definitely.
and I saw that, I'd be like, I'm not living with them. I'm gonna be, you probably made some buck, you know, that toilet, whatever, got drunk.
Why did he want it?
What?
Why did he want it?
You never explained that part. Hey,
Hey,
did you already get a verdict?
no. I'll keep my note.
Why didn't she just flee?
You wanna go talk to her again?
Well, yes, how did that work out for me with Kirsty?
I don't know, you had good rapport with the other one, so. Like, was it Glengarry or the Shirley? The
Surely, yeah. Well, good luck.
Thanks.
So the beauty of it, is that this was one of those transcripts when we were reading a certain witness
Yeah.
testimony. You could only read like 4 pages. And then you had to go do the dishes or start a little laundry. Then you could come back and maybe read a couple more pages. And then you would have to go, I couldn't just sit down and read testimony. It was so hard to read that transcript because I anyway. I don't like doing to come nervous at night. Yes. You're leaving on your cat or your dog, it's like, oh, Johnson, anything that's defenseless, you have such superior power. But I have to write the appellate court. The appellate court brief is due on January 9th. And I sit down and I type like a paragraph. And I just can't. I can't. And then I come back and type it. So my appellate court brief is, you know, it's not even close to being ready to be filed. And due on January. But a few days after New Year's, sometime that first week, the jail comes and informs me. And I'm like, I need proof. I need proof today. And so says, why don't I get you proof today? But I'll get it by then. I said, I need proof by then. And I go ahead and prepare the suggestion again. And I have it all ready to go. It's got the wrong date on it. All I gotta do is change the date. I get the whatever from the jail. Senate.
Yeah.
Those weeks, no, but got the dead point, Bristol, Jackson, set number 2, level, good. I attach it, I submit it, and then I contact the clerk. I say, he's dead, and I please be excused from filing this briefing. And she says, I just received a suggestion of that, we present it to the panel, he's what they want to do. And then within a day, we feel dismissed. Within a day. Nobody wanted to deal with it. Trial counsel, Baldwin County, and it's in the Baldwin or Hancock. It's Hancock. Hancock. It was one of those. Every attorney, the attorney general, stop it. Baldwin or Hancock, I think it's the same circuit actually. That made me, when he saw us, said, are you sure? Is he really dead? I said, I'm positive to contact the jail. And a few hours later, I gave me, oh my God, he is dead. So we don't have to file these briefs, you know? Because his brief was due 20 days after mine, and he was, I couldn't see it, but you could tell by the tone of the emails that he was jumping for joy.
Yeah, my father's a defense attorney in the so he tells me all the time. He's happy that he doesn't have fathers, but somebody he's had some clients die in prison as well. So
I just had a gangbanger die. But it was on habeas. The direct appeal was finished and it was a pending habeas. And they contacted me and asked me if I wanted them to send me the case file so I could send it to his family. And I said, I'm not his lawyer. All the habeas pro se.
yeah,
I have no contact information for the family. So she said, okay, we'll stick him in the file, but if they ever contact you. It'll be close. Whatever, it'll just block it.
Yeah.
I have one of my clients that had agreed to flip on a gang. Gang leader, who was a co-defendant, we agreed to flip. They paid family bonds, who agreed to kill them on the street. For about 20 bullets in it.
How long have you been on a bond?
Examined the bond after. He paid it. He's just able to just put it back and do it. It's a message. I'll tell you what, I couldn't do this every day. I just got appointed to a trafficking marijuana case. Yes. You know,
What county?
a good old drug case.
What county is it?
What? Oh, we're not, I'm no longer taking cases. Like the judge said, I'm transition.
So it's just kind of,
Yeah. I've got 2 transitions. When I'm leaving all counties except Compton and state transition out of the educated college professor. So after I left here last night, I walked straight to class.
were you able to make it?
You know, graduate classes are different. Almost more like a 3rd-year law class. Think about your 3rd-year law class where there was not a lot of people in it. And by then, everybody knew each other.
Yeah.
And you knew the professor. So it's not like an undergraduate class where you walk in, you know, there's 20, and you might know one person in the class, you don't know the teacher. So there was 10 students and the teacher, and we all know each other. So I got there a little late, but they hadn't actually started doing the class material.
Okay.
Because nobody's seen each other for a week. And imagine that you see, you know, some of your friends that you haven't seen for a week.
Yeah.
You don't just, you're gonna,
You walk
Oh,
in, it's
hey.
like cheers, yeah.
yeah, you catch up and stuff. So they were still in that, hey, how's it going? What'd you do? You know, the teacher was still talking about Israel. I think he was talking a lot about how much he hates Donald Trump. Stuff. He's as Democrat as you can get, which, you know, it's fine. You're libertarian, I don't mind it. That's all right. I'm looking at the map right now. And it looks like he's somewhere sobbing into his pillow. He was talking, and he had his I voted sticker on. But most of the first part of it, before I got there, I'm sure was talking about how Trump is going to end American democracy. I don't think you can really do that easily. I think if you start trying to end American democracy, there's going to be a pushback. Sure. Agree. So I'm looking at the map right now, and Kamala's in big trouble.
Have you been at declared him?
Well, you know, there is 270 something, and, you know, Pennsylvania, I think it was Wisconsin is really close. I don't think there's enough votes out there. I was just doing the math on Michigan. Based upon my math, in Michigan, there's about 110,000 votes out. And Kamala would need 100,000. Well, you never know.
What counties are still, is it like?
That's just it. They won't tell me what counties are still out. But I did the math, and it was based upon the number of votes that have been cast, that there's only 2% left. So you take the total number of counts that have been cast, and you can kind of get an idea of what 2% is. And then you can do the difference between the two and say, well, of those remaining 110 to change the outcome, she needs 100,000. Wisconsin was only 30,000, and there's a percent left there. They have a lot fewer votes. And Pennsylvania, he's up a bunch in Pennsylvania. Pennsylvania can't turn. He's up by 150,000. Michigan was up by 91,000, but Wisconsin not changed. It's only up by 30,000 with a percent. Then obviously if he loses Wisconsin, then all of a sudden he's got to live up. The Alaska's the bottom, whatever, so the bottom is up by 60,000, 12% now. Arizona is up by 100,000 with, well, yeah, Arizona's not even close to New York, is up 100,000, 37% out. And I'll do the last one here. Alaska is up by 30-something thousand. 29% now, but 29% of the Alaska vote is not that many.
Yes.
Probably like 50,000 people.
I wonder if the map is exactly the same.
It's like really close, except for he won Wisconsin and Michigan, and I think he won Arizona. I can't see 2016 or 2020, Biden, Georgia, Pennsylvania, Wisconsin, Michigan, Arizona, Nevada. But I know he won all three of the blue wall states. And I think he won Arizona. I'm not sure how. And unfortunately for me, I'm assuming you're a Democrat.
Yes.
You know, the weird part about me is I'm a libertarian. I pretty much get along with everybody. Just everybody knows like it's a loser. He's not a threat. He just wastes his vote every year. And it looks like they did take the Senate. Well, yeah, y'all didn't have a chance in West Virginia. When Manson resigned,
Yeah.
then Ohio and Montana, you have to go for record. But it looks like they did it. Wisconsin, Michigan, and Minnesota, and Arizona. I don't know what it, you know that Arizona candidate, Gary Lake.
The name sounds familiar.
You know what I think her problem is, and this is gonna sound weird, that if you look at the females who get elected, with the exception of Elizabeth Warren, they look female. Gary Lake, I want to be able to see a picture of her. You ever heard of a Karen haircut?
Yes.
Okay, she has basically a Karen haircut that's shorter. Her hair is possibly shorter than mine. And I just don't think that some voters look at her and like, she doesn't look like the other female candidates. So you think about female candidates who gets elected, they all have feminine looking haircuts, if there is such a thing anymore. Traditional,
Yeah.
haircuts with hair that comes below the ear.
Right. Yeah.
Oops. We're done with it.
Of course, yes.
And so I think that maybe some voters are turned off by her because she doesn't appear like the typical candidate. So there's a lot of old voters out there who still think one should pick up this and
Oh, that's
base.
I thought my mom and dad are obligated staunchest Democrats and all this stuff. It's like that.
Yes. Yeah, my dad is a rabid Republican. Sometimes I just don't talk very tall. Because he attaches ill motive to everything. He's one of these people who something happens and it can't be a coincidence or it can't be unintentional. Everything is on purpose for evil reasons. And I'm the opposite. I always get everything that good out. But it looks like you are going to control Michigan, Wisconsin. Of course, Michigan is never playing. And Arizona, Wisconsin, Ohio, Montana, Florida. And Pennsylvania looks like it's going to flip, and Nevada may flip. Nevada's really close. And Nevada, the Republicans up by
Exactly, 1,200. 12% out back and what is it? Pennsylvania. Republicans got by writing 53,000 with 1% out. But I'm a political scientist, so I love this stuff. And the beauty of it for me is that the results never puke me out.
Yeah.
You know what I mean? I'm like, you know, I honestly think that under Trump, I will actually have to pay taxes. I don't think Kamala's clever. She's going to reduce my taxes for true. I do believe Trump will try to limit my taxes. He does or doesn't. Oh well. So all I'm gonna do today is just sit here and try to respond to all these emails I get.
Yeah, sometimes it does get ridiculous, and I made the mistake of not putting on auto reply that I was in trial, so. I see her phone, so it's just, how
Oh, you try this horrible. You might be so not get I get a trap. You're trying for years. Cartel got you know. Party bro. Cocky. You had to dope in your car with walking it to you. But, you know, they're trying something stupid like a boat. Yeah. But even the gang shootout murders, not bad. Trying really like so. That's all she does. It actually puts it together, something that could be wrong.
the fact that we call out to every single one. But honestly, I'm only reported on 5 or 1 immediate child care because of
Go back. Cop.
Yeah.
Back when the judge gave their trial now, she was like, okay, this case is really old. Right, to try it on blank, ready. Oscar says, well, Judge, I have trial relief right before. And she says, I don't want to make you have to do that in public trial. How about 2 weeks later on this day? And it's listen, I don't have any trials in that time frame. That would be great. And the judge moved the trial to accommodate prosecutors' schedule. I've seen her do similar things for defense counsel. I said, all the debts in the context of the offer. Perhaps which is this county is the same area. They're about to be extended. Based on my schedule. He didn't really tell me to fuck off during this time. What did she say?
I was
locked something.
right in between the door when I heard that. I heard off, and I'm not saying it's just.
I heard the fuck.
But
I didn't hear the off. I heard the fuck. The judge was standing right there and said, I didn't hear anything. Bullshit. He did tell me to fuck up.
I would assume that that's correct, but I cannot.
Come on in. How's McDonald's?
Morning.
They're in the back deliberating.
I beginning, I told her that I was just sitting on the case that has tried one of the first couple of witnesses mentioned the defendant would be in jail.
Go down. Yeah, that's probably. With the switch.
She did. He did. But then I had a child molestation break actually today intended to do. But it's me. But I had a problem of judgment occurred, sitting for the judgment with the this case. Kind of the case. Put money into this case. About,
I think for the practice and other jurisdictions, I am. When I left the chief, we could see with all the recruiters in the entire state, 15 million places. And me and my deputy director, we back here. We have that, thanks. Arnold Williams. I heard some of the stuff he was. Can't say everything. The boss's best friend.
Oh,
yeah. What I couldn't against.
keep that.
I had to keep getting him out of contempt. Because of his tactics. So I, did I ever tell you why I left?
No.
Okay, so my deputy director did not like spending money. She wanted us to do all the appeals in-house, no matter what. We had a lot of cases where I felt there was a conflict and she did, but we were constantly at odds with her about whether or not we needed to represent multiple defendants on the same appeal, on the same trial, at the same time. We had a big state issue, but we had one case, 3 co-defendant trial. They hired one private attorney, and the private attorney represents all three were convicted. All 3 want a appointed lawyer. Our main argument is that it was ineffective for him to represent all 3. So I say, we'll take this one. This is the hardest one. We need private lawyers and hook it to these others. And she says, you don't represent 3. I says, I don't think that's ethical. She says, can't you represent 3? I says, well, that's going to deflate our main argument. Our main argument is that it was ineffective for one lawyer to represent all 3 in trial. And if we have one lawyer representing all 3 in appeal, kind of deflates our argument. She said, no, it doesn't.
Yeah.
And so that appeal just stuck. Greg McMichael and Travis McMichael.
Yeah.
All 3 go to trial, all 3 lose. They all 3 want appointed counsel. Public defender takes the easiest, which is the guy in the truck. And we get transferred to my unit, Greg McMichael, Travis McMichael. I say, the Travis McMichael is the hardest of the 2 since he's going to ask the full. Okay. We got a point for Greg, we can't represent. There's no legal representative. Says, I'll contact them and see if they're willing to waive privilege. They'll say, you know, you're not going to waive privilege. We want our own. How about my own lawyer? I don't want to share with you. So I go back to her and say they won't waive the conflict. She says there is no conflict. You represent 2 whether they like it or not. I say I can't do that. So the judge schedules a hearing. The hearing to determine representation. We go down there, the public defender stands up, says we're going to roll. I stand up and I say we're representing Travis. It says who's representing Greg McMichael? He says, are you also? And he had already heard it. He says, are you representing Travis or Greg McMichael? Also, I says no, you can't represent Greg McMichael because there's a conflict of interest. He says, what are you going to do about Greg McMichael? Are you going to appoint somebody to him? I says, well, we need to appoint something to him, but given the amount of money that we typically pay attorneys to do appeals, we're having trouble finding a private attorney to take the case. We pay $3,000 per appeal. Take the Greg McMichael. It's like the dummies who took the YSL trial for $5,000. Yeah. Or 55 or whatever they offer. They took the YSL trial for some, like, whatever. That gets into the newspaper. By 9 something the next morning, it's in the newspaper. I get a call from my deputy director. It says, why did you do it in the newspaper? About the private. I get it. What's in the newspaper that you said that she goes through basically on the side. That wasn't an interview, that was a court appearance.
Right.
She says, so you told that to the judge? I says, yeah, it was a court of law. And the judge was asking me questions and I was answering. I says, what did you want me to do? And she says, should have either refused to answer or lie. Should have refused to answer or lie. And I said, Kate, you know, I love what I'm doing. I love representing these people. but I can afford to lose my job, but I can't afford to lose my car license. And she says, well, you've got about 2 weeks to find a new job. Because of that newspaper. Because I refused to lie to the judge. In any event, 2 weeks later, I was allowed to resign. I come out with no income, no cases, no job, really nothing. I started, I didn't make a penny in November. I did not deposit no penny in November of 2022. I go on to Fulton C3. I go on Gwinnett, I go on Cobb, I go on Douglas. So I cobbled together an income. It took 6 months. Because what did I say for 6 months? I started making a little bit of money. I'll get paid for this trial to Cobb, Gwinnett, Douglas. You don't get paid till you close the case. Yeah. It takes 6 months before I start getting money. I did take some misdemeanors in Cobb County, and it's crazy. This year, what they tell me?
My wife was briefly a secretary before.
Yeah, I'll bring a project that they part is with or something for. You know how many hours I spent just sitting really you. I go home at night and I cross through everything, closing ready. I am starting to make money now. But I'm overwhelmed. Yesterday, I had 7 million cases from Cobb. One of them has 2 probations, so that's that 9 cases, and I just got a new COVID case from that. I have 200 COVID cases, but I went from 0. So I'm so overwhelmed now. It says, okay, I can't do all 4 counties. And I said, which are the 2 counties that treat me the most poorly? That's easy. Douglas and
Cole starts with that.
Douglas and Fulton, so I said I'm no longer taking it. What's your game plan? Are you a lifer or is this a temporary to transition to something bigger and better?
At this point, I originally had I did around 6 years long.
Huh? Judge.
Started
Private.
other things, federal.
Oh, fat man, they pay good.
Yeah.
Oh, if you get over the federal prosecutor.
Yeah.
Okay, you said you're full of me. People could ask, what's things that you do?
Oh, wow. This is really close to me. I probably just come to you. Look, I got the worship.
I did the same thing with you. You know, I met the US attorney. Really? Yeah. In an event at Georgia State University. We were on a panel, some people, security, some from the federal office. I don't know what I was doing. Yeah, I have no idea. They put me on that panel. I'm sitting next to like, yeah, be from the Homeland Security, US non-state, US Homeland Security, again, US Attorney for the Northern District of Georgia. Head of the Federal Defenders Agency. And I'm not hearing.
You got to get on that panel for some reason.
Maybe because I was a student there. There was somebody else on the panel who was kind of, very sitting right. I remember he kept telling the students how great it is to be a lawyer. He has the greatest life ever. And I looked at the students after he finished. I says, yeah, because there's only 94 of him in the entire United States.
Yeah.
Now, if you can get that job, yeah, your life is going to be great. But there's 100,000 lawyers who don't have his job, and their life is not like his. Their life is like my life. And I said, it's basically like, a singer. A few of you are gonna be Taylor Swift, and the overwhelming majority of you are not gonna be Taylor Swift. And Taylor Swift's life is not gonna be like the other. He was cracking. We kind of, if you ever want to, I can send him an email and say, hey, you may remember me, I was this, I know this fabulous, excellent prosecutor. I appreciate it. You better do it quick because I don't know how much longer he's gonna have his job.
Right, that was my process as well, just the bug that my father took me to. I'm waiting. Turns out. My father. Stay out here for guys.
Well, I mean, I know Merrick Garland is gone, and I know Jack Smith is gone. But I don't know how big of a purge it's gonna be on individuals who are not at that level, who are not personally involved in prosecution. Clearly, anybody in Jack Smith's office is involved and would never be hired under his administration. Clearly, Merrick Garland is gone. And probably some of the other people. But I don't know that, I can't remember his name now, but I don't think that it has anything to do with Trump's prosecution. It is fine. Yeah, you can't fire her. But if what the Democrats are saying, he's gonna basically take all her federal funding away.
I think that's a possibility, yeah. Typically how it gets there, but
It won't be because they're prosecuting for their offices. It's gonna be because they're sanctuary city. Something else.
rationale of that.
Because I would be smart enough to not say, I'm taking your funding because you're prosecuting me. He's just that stupid. He's just wrong.
That's where it's about things that I don't want to do. So
He doesn't think before he speaks. And I was thinking this last week, and I don't think it's changed the outcome. Liz Cheney went on TV. With that, attacks me. And one, it's a political game to attack somebody who's completely out of power. And, you can certainly say she's a war hawk and she wants to send your children off to war to die. But you don't have to add in all that colorful stuff. Let's give her a gun and put 9 guns at your face. I didn't say all that. She would learn how to keep this.
I do.
Just keep it. Implement the policies that I need to implement.
That would be nice. That would be nice.
I'm just sitting here watching the email pile up, and I guess I should be responding to it.
I might go duck my head at HC real quick to see how they're doing. I think
Yeah, I'm just running my mouth because you're sitting there.
listen, I'm here.
I was expecting the question pretty quick myself, but
Me too. I was expecting a question. Everything needs to go. This makes me feel like I'll be okay to jump over to HC for a minute.
so this is, I'm stopping taking cases in Cobb State Court now because it's changed ever since Matt took over. So there's a domestic violence case.
Yeah.
Listed. And my client has a bond hearing through the magistrate court. And then the night before the magistrate court hearing, they accuse him. So I go to the jail, Cobb County Jail for bond hearing, sit there for half the day. And then when they call my case, the prosecutor stands there and says, oh, that case was accused. You don't have jurisdiction, you'll have to file a bond motion in state court. And I said, when was it accused?
Yeah.
He says, yesterday. Did you really tell me? No, we didn't. After I sat there all day. Oh, and I was thinking, maybe we could say something all the time.
So anyway, so I filed a bond motion, the judge won't schedule it. I don't like that building anymore.
What judges?
I think it's Bowers.
I
So
started,
finally, his girlfriend is blowing me up. And she finally started to call the board commission about why has he had a bond hearing? And they say, Mr. Shepherd, why is this man in jail? The bond, I said, well, here's the bond motion I followed on October 17. Here's the email I sent on October 29, asking for a bond hearing, asking for a bond hearing. And so they sent an email, well, we can get it scheduled unless the state's willing to consent to a bond or dismissal. So the prosecutor is like, oh, yes, we will absolutely consent to a bond. This is a misdemeanor. So we will consent to a $45,000 bond on misdemeanor domestic violence. With a victim who wants him to get a bond, doesn't want to prosecute, and actually sent an affidavit and an email to the prosecutor and sent an email that it said, we tell that victim witness advocate to stop contacting me.
there's a chance that they put just like 2 zeros in that bag, up in 4,500.
Not this prosecutor. On a misdemeanor domestic violence, she wants 24 served 12 months.
What's the prosecutor's name?
Jennifer Jack. But it's coming from Mackey, it's not her.
Okay.
Mackey changed everything out there. On a misdemeanor domestic violence. And the evidence is that the girl was nagging him about finances. This is from the girl and the police. The girl was nagging him about finances, basically drinking too much about. So she comes over, slaps his drink out of his hand, and then starts punching him. And he stands up and just boom. Blood. It's her one time. And some other charge, so she can go to 24 years. But the girl initiates it. Reacts.
Did she say on a body cam that she initiated?
No,
She doesn't.
she's drunk. She's mad. He just punched me for no reason. But she does admit she slapped his drink. That was
That's the one. I don't think I did that. Or they tried to get me to the next brothers.
yeah, because the victim sucks. Look, she's mad. And she says things. And then when she calms down, she's like, either it happened, but I shouldn't have said it, or I lied. And to prosecutors, they would really understand that when a victim is mad, they will say things that are not true. This whole concept that no victim has ever lied or history. Only a great weekends. It's only a family sleeping in the basement. Or something. The regret rate is one of the hardest things we deal with as a
I had a mother
Monte Wong.
Yeah.
The regret rate. Goes up to the hotel room. All the way from Hamilton County to go to the tent. They go upstairs. And this is the problem. This is why I'm so glad we're getting off that case. Well, first of all, the prosecutor, all the 10 parolable, no sex offender registry in the county. But the big problem I have in the case is they asked her, well, you weren't planning to have sex. Why'd you go involved? Why we made a bed with him? And she says, we wanted to watch TV. Like, we watch TV in Henry County. We watch TV in a hotel bar. We send our investigator up there to take pictures. It's a suite. There are 2 TVs. One in the living room and one in the bedroom.
Yeah.
So her objective was to watch TV. Sat in the living room. Called him her dad. I think it's regrettable. Yeah, because the victim's lives and he always wants to retain it. You know, I have a man-on-man DV case where they just finally offered me time served because the victim doesn't want to testify. He wants to get it on. This is not getting no action. Listen, it's a hundred. And my guys, the wife, the husband, wants to get 100 much back. This guy. Oh, yeah, he got probation and revoked his probation. So he had 2 years of probation, was arrested. Finally had the hearing, she revoked the balance of 670 days. And they didn't put the word on. And he was excited about witnesses. We were not excited about witnesses. He's standing there, he's upset and mad. And the police officers asking him questions and he's responding to questions. And the idiot judge said, oh yeah, he's excited. That's an excited about it, which is not. Excited about it, just a spontaneous statement that is not prompted or response to a question. That's not an excited utterance, Judge. The police officer's asking him questions and he's responding.
Yeah.
That's not an excited utterance. Excited utterance is where the police show up and without any questioning, the guy just says, the defendant's the one who shot me. It was him, he shot me. Anyway, so the prosecutor this was yesterday, just came down from, I think it was 20 or 15 served 7. And she just came down to 2. And she said, in her email, she point blank says, computer, it doesn't add any jail time.
Yeah.
Because they can't get the victim to do all it sucks for being the prosecutor. It's like, come on, I'm trying to help you. This, and they're stabbing me in the back. But if you could get over that federal, they have so many resources.
Well, I wanted to do this. My dad is U.S. attorney.
You ever been in these courtrooms, there's 130 people on the calendar.
Absolutely.
It takes 2 hours just to come in.
Very first, I was able to check out 2 years. Yes, no, the doors.
Oh, yeah, well, look at this, look at what I'm doing.
Clicker, yeah.
Right here.
It's
Look
just,
at this.
the no arms, no, the mask, all that stuff.
Ma'am,
No, ma'am. At the very first trial calendar, I had 77. Of course, she was not on time.
oh, never.
And it just took forever, just to do it.
I remember that sometimes the deputy would come out and say, hey, Mr. Shepherd. Hey, who are you? Who are you? Okay, then he would go in the back.
Yeah.
And then an hour or something later, Judge Adams would come out and I remember it was possibly May or somebody was in the room came out. But she comes out, whenever it comes out, really, the first thing the judge is down there. Says, Jackson, I want you here at 9 o'clock. Is that like 11? I was here. I was in the room. She says, well, the deputy says you weren't here. And she had sent the deputy out to take attendance like a high school. And they started yelling at Miss Jackson because she wasn't there. And she was here when you came out. Yeah. But here's a good story. So one time I'm at the movie and I got my cane. And he was finishing up. That's okay. So I'm gonna bring you back for your final plea. That's why I can pull my head out. Take my coat hat. Actually, I think I'm very happy with this. Jesus, Mr. Shire. not click your pen. I says, well, Your Honor, you're about to tell me the court date, and I wanted to write the court date. And she says, well, that is no reason to click your pen. I says, well, it doesn't write unless I click it over. She said, well, what you're supposed to do, or you come in, click your pen over, and then after you leave, click it close. And I started to say, but then the ink.
Right, it's good, and it's.
And I started, and I said, you know what, just say this. My brain was like, no, don't say that. Don't say the pen will bleed onto my suit. Just say yes, ma'am, and it'll be over. I said, yes, ma'am.
And then you get the movie.
And then the train starts moving again. I'll see how you did that for 2 years.
I got the right personality to be in there. Love everything that she said, would never have a visual expression about it. I would just, that's what she wanted to do. That's what I'll do, and I'll put it on the record. You won't hear it, and then I had a.
You seem very calm.
I think that courtroom has given me a lot of good training for like being calm under fire. And we had a terrible child porn case. Where defendant himself, sexually abusing a child, and all kinds of videos and shared, all the things. And victim's mother, for whatever reason, prosecuted.
Oh, well.
We needed the lead detective because once he got the phone number, which led to all the discovery of the child. He was out on FMLA leave, and he had a sick child, brand new, sick. And did my motion to continue, and she didn't tell me that motion to continue was denied to my face. She told one of the other ADs to tell me that she was denied. From that day on, I never filed a motion to continue. I just always assumed that it's not granted, but so it is what it is, and I just learned how to adapt it.
So I Trump leaves. So back to my ultimate point is that when I came out with the Red Company, I went on to 4 counties, and I realized that Gwinnett County, and I could do 2 counties in a week. Because I'll look at my calendar and say, I'm going to Gwinnett and Gwinnett. I'll finish my lunch, I'll go to Cobb, and Cobb go on. I'll go to one and to get to 3 counties in one county. You can do it, but it's hard to get to 4 or something. On days where you have, like right now, I'm in Cobb and Douglas and Greener. I'm not going to get any, but I would have to get to, but I think it's going to be the shortest county first. You grind the deed, and then you have to get to your second county before they break for lunch. Because if you don't get to that second county before they break for lunch, you gotta get to that county or 2, then you don't have time to get to the 3rd county. If you can do your first county quickly, get to your second county, finish before they break for lunch. You can get to their lunch, get to the 3rd. These get I've done 4 occasions times. So having about 8 cases left in the database, I mean, now I'm very clear to see the county of 5 that went 4. The only 2 big ones I have is Marcos. I have another case with the 3 code thing, something to these. Always have an accuracy on here. Is a very valid business. Make a decision. Go tell whoever, this is what we gotta do.
Yeah.
Some attorneys, district attorney thinking are afraid to go to whoever and say, no. This is what we need to do, that just cave. I want to get in that conversation. I have a huge amount of respect.
That's always been my thing about working for communities and honestly, other reasons. So perfect mechanic trial. All I was supposed to do to be exactly. My case is not a case that you can try, or this is.
Yeah, give it, she told me to fuck off, I don't still have a lot of respect. I'm just amazed the judge didn't say something. He was right there. He was between me and Laura. I heard it
Did she say it when she was at the table or when she was walking?
as she's coming through the door. You heard the off.
I heard off,
I heard that.
and I heard,
I didn't know first.
I think I heard off.
I know you did. Did that makes more sense.
And that wouldn't, yeah, I would never hear somebody say freedom.
That was
I
the,
I can very much see it.
yeah, it was fun. But I thought I might have been. Couldn't quite make out. I'm not at all here with you. I don't know. I truly like the same English. And a Peter Paddock saying things. That's what people understand. I still have a huge amount of respect, because I got good, yeah.
Absolutely.
But Reeves came in to court during our final plea. Of 3 co-defendant murder, and apparently the GPDC attorney, Sean Hoover, is nothing like our old ratings.
I like either one.
Yeah, Hoover's a great guy. And they had made some sort of counter offer. And the offer was life. And Reeves comes in and says, hey, we're going to accept the counter offer. We just got to do what we got to do. And I said, I don't know what the counter offer is, but if it's not life, I want it too. And Reeves looks at me and she says, no, you'll probably get something better. I says, send it. Let's do it. Let's do it. Because I've only got 2 big cases left now that I'm off Montague.
Yeah.
With you and with Reeves, and apparently you said Judy and your co-counsel apparently are close to doing something.
I think we not negotiated to either 1 or 2 travel stations was the last that I heard. I need to step out and get the car because we handled a bunch of cases from the while I was in here. So
Okay, that'd be great.
Yeah.
You know, my theory always is if the state, the judge, and the defendant agree to it, I don't think it flipped what it is. If you get him or agree, there's no way on earth I'm gonna say, no, that's not fair. We need whatever you 3 agree to. I close a file. I don't care what it is.
I sat down with that case and sat down with the cases. I could never tell you how different it was to sit down. Alexis was excellent in spite of being. She did this to me, was livable, and then he sat down. Oh,
What was mom like? That's my client's ex-girlfriend. Come on, I'm not gonna use it against you at trial.
I understand that there's a lot of
Anger, looks her ex.
very much a lot of anger.
Yeah, I already knew that.
Your daughter gets to allege something like that, and we don't understand. And we understand that the old traffic station. So I did not get any comment.
Oh, yeah, we're gonna open her up.
It's gonna be guessing.
Yeah, we're gonna open her up.
I said,
She's gonna want to. She's gonna want to spew, hate that pound. I'm just gonna let her. Jesus. Turn the jury off,
especially
because it's gonna play into our defense.
if he dismissed the case against them, because that could be mad at you into your life. Their relationship. Those charges were dismissed. I would think. I have been telling him, okay, we understood the situation to revise and not respecting him for making that decision. It was so hard to be differentiated between this, and actually you have to. Because, so. But that's me personally. We had a,
You heard me, like.
oh, absolutely.
And then we don't have to go down that road.
I'm with you. I'm saying.
I don't want to do this. But it's also, faulting one. She's very busy. She could have made that after 2 months ago.
Just keep doing
And then I would have had time to work on
I'm with you.
it. But the morning of was at the final hit, she said, like, look, I can't believe the math. Pretty won't take me.
We had a case that Adam was going down as a had similar situation. Yeah, similar situations about those birthdays. And it was a strange set of things because when I was in prison, seven occasions.
This is
This is, yeah, this is, the, one that, it was a Florida situation. She's in prison in Florida. Defendant contacts her and says, and child looks a lot like me, and he's my child. He makes it seem like, yeah, it's crazy. I've never had anything like that before. She makes it seem like she's just ignored it and then stuff. But okay, we'll look into it. We look into it. It's correct. I asked her, so, don't you correspondence? It's a big number. You come get to try, and then that's also very, very that's also so that's about it.
Oh, she just said that. I can do it between now and the next trial.
Which is where we have to clean out outside the sheet. It just, that was another situation where the victim, there was this goes. There was just a few inconsistencies in the drug court situation. It's like 6 or 7 years ago. So it was a process. So she was asking, she was ready to and I think that the jury, even though he wasn't able to admit the letters into evidence, the jury didn't pick up on it. They didn't pick up on it was dark. Nobody could instruction or correct it, or if the jury's not supposed. I hate those things. That's why I'm so proactive in trying to not let the cat in the bag. That's why I jumped up during her closing. I thought she was just going to play other parts of, she played part of Timothy's tape. Yeah.
And then I didn't really catch that she was playing something different. That's why I jumped up, because I didn't want to, after she had played it, then I was, oh, disregarding it, just heard it.
And then I went right over to the.
And she didn't even, maybe she did, and I didn't catch it signal that she's playing from a different incident. And I can't tell the difference.
Yeah.
I think that's it. Yeah, as a defense attorney, I've learned that the correcting and striking doesn't work. Motion to strike doesn't work. And that is, all you do when you object is call attention to it, unless you can object before whatever it is heard. $45,000 misdemeanor. That's Mackie. Did you ever work with Mackie when she was here? I hate to say she's completely train wrecked that on this. It's misdemeanors. Out there going after like it's probably. First DUI the other day, the offer was 90 days of jail. The first lifetime. Guy's 35 years old. Nothing. Never. No prior arrest. Some traffic stuff. 90 days. On the first lifetime. Yes. He had meth in his system. I get it. Drug test, blood, whatever they took, proved positive. He's driving with meth.
5 years. Probably there.
I had to give him 48 hours. And rehab.
Yeah.
But I'm a libertarian, so if somebody's using dope, I just don't believe in prison for using dope. Now, I'm a weird libertarian. And a lot of the other libertarians don't like it, but that's true with a lot of people don't like it. The other libertarians never like it. Because I feel as though that if you are a drug trafficker, you are preying upon weaker people who have an addiction. They're basically making their lives worse, so your life can be better. And that you're basically feathering your nest at the expense of these poor drug addicts, so many drug traffickers should go to prison, and we're going to be drug dealers. She gets some county. The producer and herself is not here. It's like an addiction. Prison. Yeah. Especially for the first. Yeah, not for the first. Yeah, the guy's got 4 prior coke convictions. I mean, it's just very, it's like having junkies. Right.
I was there on a very important. Did not have it was by the time I got there, it was Chris Lanning. Yeah, it was Chris Lanning. I was essentially running the office day to day. Barry was taking over. We just stepping on two serious spaces, bro. But my wife and I were involved in a campaign. We had a discussion with him. No, for Chris Lanning. When he ran, yeah. Yes.
Yes. Although, now that he's on the appointed list with me, he says he'll never go back to prosecuting. That's what he wants to do. He lived in his wife.
Yes.
I never heard of that count. He's in Bo McClinney's court. Yeah. But I love it because I get great data. She texts me and says, hey, we're just show up. Thanks. His wife is the sweetest thing ever. And I'm very grateful.
They're both of them are excellent. When I used to park down at the Jura parking lot and cross in front of just looking for it, I would see it all the time. But I parked in the underground. It's awesome.
Yeah. But I did not know you were in that office at that time. It was so easy. So easy. You get the appointment. Get the discovery, contact the solicitor. Unclined offer. Lay it out so that they can. Now you've got DUIs on your shelf for 2 years. Because you know, I'll go to some minor jail time. No offense, she is totally clear about that. Did you ever work under her, or did you say I'm gonna have it before she shows up?
I went to Clayton after that. I came here. We would sit down with Paul Chopra or Terrence Bradley or Campbell who would come, get all their cases together and just sit down and work all out. Terrence, yeah. Terrence actually, he didn't introduce me to my wife. Really, one of our first sit downs was Terrence Bradley, my wife. That's how we started talking.
Such a good guy. He just took off. He just took over one of my project cases, which I'm happy with. So I sit down and I said, push that in. Now, Clayton, I have one case about Clayton. It's because I'm in the findings. Nothing to do with the judges or the prosecutors. I make that hike out to Gwinnett.
Yeah.
But I have 80 cases out there. And you have just one case in a county. They're driving all the way that far for one crummy little fee. And it's another junior.
Who is that one? Or what is that?
I think it's Joe Scott.
Joe Scott, okay.
I don't know who the prosecutor is. He's been in DOC custody for so long.
Okay.
Nothing's happening on that case. I think I've got a Judy Kim in Cherokee County, Judy Kim with you, a Judy Kim that I just got off. that I got a Judy Kim in Hall County. It's like dead in the water.
Yeah.
And it hasn't been indicted, and it's been like 2-3 years. Just dead in the water. So normally it's gonna be that 3-year and 11-month indictment. I'm trying to, share, Hall County, that's even further. But that's interesting to learn that you started in Cobb, went to Clayton, and now you're in Fulton, and now you're going to Federal. I think that's a great career. You're gonna love it. It's fabulous. Unlimited resources. Unlimited resources, and they got support staff. And there's 2 attorneys on every case. I mean, 2 actively participating attorneys, not an attorney. So it was supposed to be public. I guess I should have asked Lauren this, but maybe you know. How many victim impact statements do you have?
That part I know. And we have to share with you. I would guess that this.
Discuss with them that you can say everything you need to say in 4 minutes or less.
We'll definitely have that conversation.
I remember this one victim impact statement was like 10 handwritten pages. And even Judge Newkirk or whoever it was put down the DA. It's okay, we found it. For the next witness statement, can we condense it down to that which is essential? The person talk for 20 minutes, 20-30 minutes.
How much time it allows us to really look at it. That's how I would do this particular case because of the age of
They need closure. And if they need closure, I know it's therapeutic. But I still was amazed at that. Nobody said anything when that victim impact statement in Douglas County turned around, looked straight at it and said, I hope somebody in your family dies. I'm like, what does that have to do with the victim impact statement? That says hate.
maybe the parts.
Yeah.
I understand.
Oh, and they were, all of them were turning around and speaking directly at my client and not saying how the death of the victim had impacted this board. Which you did, it makes you, you are an evil and hateful human. You are disgusting. Just attacking them rather than with how the death of the victim has impacted. And there's Dia Warren, 44 county prosecutor, just a voluntary. I've got a gang of pointed things. The fact that I zealously represented my client, that I showed her and did my job, wishing death on me. That's what I do. I started to say, but this was like Judge Adams, say that. And then he said, no, say this instead.
Right, yes.
I started to say, unlikely, because nobody in my family's a drug addict.
That would have been explosive. That would have been explosive.
But it's amazing how many times I think of stuff to say, and I'm really hard to say that.
Just keep it inside.
Yeah, but the fact pattern, and it was a horrible fact pattern. Is that my client's nephew is a drug addict, and there's a meth addict, and same thing, you're taking advantage. So they're fronting and go, fronting and go, fronting and go, fronting and go. His father had passed away, and they were settling in the state. And there was a big dispute between the family and the decedent, because he was basically selling off property out of the house to fuel his drug habit. Or like, wait, those are estate assets you're selling and monetizing to support. Finally, the guy gets about $2,800. And the drug dealer decides that he's going to sign over his card, which is technically his dad's card. They go over the document for him to sign the person. And he basically tells her, they whack it in the head with some whole companies. than duct tape. You got to Google up.
Yeah.
Just Douglas County, Georgia, duct tape murder. Find doing duct tape and sticking in the bathroom. Guys in the bathroom. They left one nostril half open. Oh, okay. Is it up? Yeah. Oh, it's not allowed. Never mind. Charlotte did it. Yeah, that's it. That's him. That's my client. That's the nephew. That's the girl who drove her. So she drives him over there and stays in the driver while they kill him. And she drives him away. She flipped and got going. You got life without that 2 life for the parents. That was fine. But also crazy too. It was a horrible person.
Is this like burger?
No, he's all tatted up. There's evidence that he's in the Aryan nation. You gotta love those guys. What a bunch of hateful humans. So anyway, so my point being is that I'm a point and you're spewing hate at me because I showed up and did my job. I get you're spewing hate at the defendant. Maybe that's when Judge Warren should have said, wait a minute, this is a an impact statement, not a that on the defendant, it's counsel. But Esmond Adams, yeah, she runs a tight show. She runs. Hey, how's it going? Do we got a verdict? Oh, man, I got lunch plans. You know, I'm gonna be honest with you. Anything for now. I don't care. But all the way, maybe I should change that because the judge just said he was gonna let me on. Plus the Fulton County C3 project's out of money. They had to find more money for me to do this trial because you weren't on it. But Warren was getting the emails from like, you're out of money. I'm not trying this case for free. I gotta get off the case unless you can find some money that they found money. So there's enough money in my allocated budget slot. It's like a budget. There's enough money in my budget item for this trial, for a second trial in this case, and not for a purchase trial.
Was it Reynolds town?
First, it was a federal grant,
Okay.
and the money came from the feds, and they were only supposed to appoint me 2 cases. And then they kept saying, oh, we've got another case. But I ended up getting like 6 or 7. So the money that was allocated to me for 2 cases ran out earlier this year. So they had to find new money. I think it came from the county's budget. So they found $20,000 more. Put it into my budget line, 20,000. And then I've gone through a budget now because I fled out a murder case. Possibly Reynolds. Another case. Oh no. Somebody took over the case privately, and so I didn't have to do anything about that case. But I had to bill for the again. So that initial 20,000 budget line is gone. You know, hey, there's no money. I need off. I did, and Judge McBurney was really specially said, I say, I know, but I need off of the money to pay. To get something, 21,000, which is just the left purchase of the community, there may be enough money left to pay for a plea, but not for a full-blown trial. So next year we'll have to reallocate some more money from it, which they do have. They do have.
Good.
There is the money there. The question is getting it to give it to me.
First,
Oh, that's
so much already.
the color.
And then today, as we sit here today,
No more federal.
we can try that. At least.
Just wait till Trump gets in office and see how much federal money we get.
That's when it'll be time to put the notes, but, so much, always go fix the price of Spain. That's usually I thought my favorite, so.
Think about how much money I'm going to burn the concert. Where people offer that a year ago. It was really good years. We got how much money I found. I don't understand. Why I'm not, you know, she's a DA, she's gonna do what she wants to do, and not criticizing her, second guessing her. Why not just take her phone and go around control? You know, one or two thousand out of trouble, laser beam focus, be in prison like that. You would be able to what? Just try to ladies to both defense attorneys and prosecutors, especially during plea negotiations. Don't be greedy.
Yeah.
I had one case where I had to take over for another public defender because there used to be this thing here called the fast track or non-compact. We would go back for the compact, so it would be for a judge level. They're alive.
Yeah.
And get offered this one person, like 5 served 1 on a possession. And the attorney says, we're not taking that, we want time served. They're like, listen, he's been in jail for 4 months. 5 served 1, possession with intent. May get out, he may not. No, we're not taking it, we want time served. Well, he has a prior possession with intent, and he's got 3 prior felonies. If you don't take the offer before we get up to Judge Leftridge, we're going to recidivize him. It's going to be a mandatory minimum 40 served. And have to do everything at your time. We want time served, but we're going. Recidivist, go up to Leftridge, and the client is sitting there. For the first time, he learns about the 5 served one. Never told the client. Then he finds out that because he didn't have the opportunity to take the 5 served 1, that he's now worth like 40 served 10. He has to serve it again. So that gets back to the key pieces. Taking off the case I can. At this point, I'm listening. Don't blame the courts. Don't blame the courts. I got them to withdraw them because they're going to take a 5 served. I was like, why 2? I was like, but my point is that when you're greedy, as a both a prosecutor and a defense, that you can sometimes do an outcome. So if rather than this massive RICO thing, you should basically not really ready for the law. It's just one defendant, one crime, one. She might have been able to get a trial before the Republican primaries. He would have been stuck with it for and I do get stuck.
Yeah.
He's stuck with his policy, stuck with it. Yeah. I remember back in 2000 telling my father, there's no point talking. He's so far to the right. It's like, I don't even like talking to him. He was talking about how Trump is going to get the election early, so it's overturned. This, that, the other. This was in November. And I said, he needs to shut up and start packing. You get it? Shut up and start packing. He needs to get his suitcase out of the closet and start putting his clothes in it. Call U-Haul and get a truck. And my father went crazy on me. Wow, he won that election. They cheated. I'm like, nobody cheated shit. He lost. Shut up and start packing.
It's hard. It's hard. I'm just entrenched on both sides of the fence. It's hard to hear.
Just thank my father wasn't up in the Capitol that day. But I know you said your father was kind of large.
Yeah.
Yeah, I love my father, but dang. There was a deep faith in
then you will lose all this.
I'm gonna look again and see if any of these states have flipped, because if he thinks he's one, 2 days later, oh, we miscounted in Pennsylvania, or oh, we miscounted in North Carolina. We're gonna go through it. No, he still has Pennsylvania, Wisconsin, and Georgia. That's all he needed. As far as I can tell, Michigan has an accountant, so we voted all day. Hey, Spring,
Hey, hi.
how's life treating you today?
Can you down there?
Are you reclaiming your space?
Not good.
Okay. We're waiting for a verdict. You know what, it does look like they may have countered a vote. If I'm wondering what takes them so long.
All works and board, what he said, like, they should be in comments, she did take some time, she should be there, to do a clock, but.
Then I know.
Yeah.
But they've been at 2% now since last night. Like, what is it about these other 2% that you can't figure out? Oh, shoot.
Hopefully I will get my bag.
Yeah, actually, he's up down about another 1,000, so we have to go in some of this. And he's gone up a little further in Michigan. Oh, yeah. Yeah, I'd love to hear what's happening,
Yeah, I definitely will.
because I'm really hoping she wins that one. I mean, I'm sorry, you don't do that.
I agree.
Oh, no, gosh.
Hey, deputy. Has anybody checked the circuit of that light lately? Yes. Okay, just kidding. Because we might have a verdict, but just the light's not working. You do understand what I wanted to happen. No questions, straight to a verdict. Oh.
You know how that goes, right? You sit here for 4 hours, you go to the bathroom. I'll be back.
Is there a part going down already?
See if, uh,
B?
five.
Okay, for the B or D? Okay.
The
So what's going on down there?
They're just like the initial officers responding, the initial responding officers got in there. And I think they're about to go with one of the detectives.
They're moving. How many days do they expect to travel?
Uh, Might be till Tuesday. Well, no, till Wednesday.
Not as quick as ours?
Yeah.
For that case?
I think so.
That case should last at least 2 weeks.
No, we had a murder last year in front of Adams, had about 30 witnesses, I think, and we got through in 2.5 days.
With that?
Yeah.
She's one word objection.
From whenever she gets on the bench to probably about 6 o'clock.
She was there. You have a chain of questions, she'll stop you right in the middle of,
Mm-hmm.
you know, there's always foundational questions, and there's always what I call setup questions. Or I guess another word, box questions, where you're getting the witnesses to answer questions before they understand what your point is. And then by the time you get to the question, you're going to realize what your point is, they're boxed in. And any avenue of escape is going to take nothing. And now they're forced to answer the question truthfully. Because all the potential wiggle room has been taken away with the preliminary questions, and they don't understand why they're asking it. So that's what this is really saying. You're alive. Right to your face. I hate it when my client gets a lot of this. It's like, I'm going to do to stop them. But I do if I have a family member who wants to testify, I just won't let them get up, especially if I can hear a lot.
Yeah.
Oh, he was with me at the time that, wait. DNA is in the girl. So was it a threesome with mom? What happened? You know what I mean? I remember my favorite, I hate to bore you with all the story.
No.
This was a client who was involved in a home invasion. Eventually he fired me and hired private, so I didn't have to do the So a neighbor sees a van parking in his neighbor's yard, and there's people carrying things from the house. Not like it here, like a painter, not just build ladders on top. You ever seen those painter vans with the ladders? One of those that go ladders.
Yeah.
So, um, and he sees these guys wearing masks, putting stuff into the van, and he thinks that's unusual, so he calls the police show up, because like, oh, it's a home invasion. Barclay shows up, he's surrounding the house, and eventually they get the guys out, like my client is arrested inside the house. But he goes through a number of defenses. First defense, oh, I'm friends with the guy, I was over there, the invaders showed up. We could be saying, you don't even know that you came with the invaders. So I was like, well, how'd you get there? Oh, I rode the bus. Okay, well, I checked MARTA, there's no bus here that goes to the house, but there's one about a mile away. Yes. Oh, well, actually, it's kind of weird, because I was walking to his house, and this van was driving by, and I said, hey, can I get a ride with you? And they just happened to be going to the same place, so I caught a ride with them to him out. I'm not.
He's radically changed.
Yeah, and then, so finally I get a call from his girlfriend. Hi, I need you to put me on the witness list. Oh, okay, so what are you gonna say with witness? She says, oh, he's with me at my apartment that entire afternoon. It was not part of his own vacation. The entire afternoon? Yeah, she says, where do you live? And she gives me her address. I'm like, well, that's about 3 or 4 miles from where it happened. You're saying he was with you the whole time? Yes. Well, I know he was captured inside the house. He said, well, that wasn't him. That was somebody else. He says, well, you know, there's about 10 SWAT officers who captured him and they fingerprinted him and took pictures of him. Oh, well, they're mistaken. That was somebody else. He was with me. I'm not adding to the witness list. Like, because I wouldn't run any of his. Like, you just need to take the 10, bro. It was your 15, sort of 10. We served 10 here. And we are taking those to rights. Do your 10 and shut up. So he fired me and hired private. And I don't know, maybe the private got it down to the parole or something better. We weren't at that stage yet where you get the stage we need to come off the 10. It's much later than that. Yeah, I told my client to come back at 12. Because I did get breakfast this morning. I was getting get out, go over and just stop for breakfast. So just dealing with these emails. So now the newest difficulty I have all day is like I said that the other day, you never get good news through. Other than she called, so I got just they called me. So I just got an email with the calendar. Like right at Christmas, when I have a leave, I didn't file the leave. Case closed over a year ago when we went into pretrial diversion. So once a case goes into pretrial diversion, their appointment is supposed to end.
Yeah.
And then if they fail out of pretrial diversion, then they're supposed to appoint a new member. Because it's a new event, a new thing. So you don't keep filing leaves in cases that are closed because they're closed. But now they're saying, no, you're still the attorney of record. But I'm saying, no, you need to appoint, one, I'm not taking new cases in Reynolds County. And two, even in pretrial diversion, I submitted my invoice. It's done. Now, you need to reappoint a new attorney, you can't reappoint me because I'm not on your list. So there's plenty of lawyers out there who can take over the cases. Who want the case. So now that's the new thing.
Yeah.
I'm trying to get out of having to show up for this 2022 case. Over on my Christmas leave. That wasn't filed in that case, so. I really regret taking cases in Douglas County. Scott County, there wouldn't even been a discussion. It just would have reappointed it. Same thing with that. Douglas is different. Everything is so different. And everything for the defense attorneys. Yeah. without even considering 100%. Well, we see, we do. Not gonna be there, so. You'll either point and then return here, start down screen. Yeah. They had some of the judges they want to see. And then somebody will come tell us they don't want to allow you to be the floor for an hour. Then you can go to that option and be back on the floor again. But I don't want you to miss that, because not for this one. I'm aside for your goals to keep in nature. I found that answer to that question you asked earlier. I'm saying right there. The Nevada was that one. Michigan is down to surgery. Correct. Assuming Arizona goes red, goes red, and Michigan goes red, because that's what we're gonna have to run again now. That is what it's okay. Now, so you were correct, with the exception of your father, you were spot on.
It's insane. As far as the, I think you get to use all.
Now, look at this. Wow. So. All the fortunately, the Sunday states. No, I thought it was like 80 to 76. I'm gonna find it now because I'm amazed that he got 80 and she got 66 so far. You wait, look it up.
Sending you down.
Oh, never mind. There it is. 81 million. 66.
Yeah.
They still do.
They're still delivering, we have asked, we have.
Okay. Usually, will you, if they go to that meeting? They could get started for.
Okay.
Yeah, Trump got 74 million. Biden got 81. Right now, Trump has 71 million and Kamala has 66 million. But of course, there's still X number of votes to be counted.
It's definitely not gonna be.
No, she's not going to get to 81 million. Trump won't be able to get to 70, whatever. I'll take a scientist. Why? He's voter turnout so low. Inherit fees. You've been talking to some of my Democrat friends. Is they did not feel that Kamala was an overly strong candidate. And given some of my Democrat, that's all my Republican friends say that's some of them said that sometimes they have trouble understanding the answers. That they would ask her what you're going to do to lower inflation. The joke that she was saying, I was born in the middle class family. You know what I mean?
Yeah.
But she answered a lot of questions, and then she would start talking, and it was kind of hard to follow exactly what she was meaning.
I do understand.
Republicans' friends just say they make these talks and the rest of the Democrat friends are nicer about this. I mean, it's a very hard job to answer those questions and fly. I'm trying to say something true that comes out as it's kind of everything's looking for is the right. Same thing with being a college professor, if you're talking about your IQ and predictions, like explaining the context politically. Hey, Judge.
Hello. The jurors want to go to lunch. They want to get lunch and bring it back and sort of have a working lunch. But I'm going to let Deputy Gordon know that we'll be off for about an hour, because they'll be out for a half hour anyway, leaving the building, getting the food and bringing it back. But I'm happy to release both of you until, let's say 1 o'clock. The computer says noon. That clock says 12:05. So be back around 1. I've got your number, so we'll call if something comes up. But they'll for sure be down for 25, 30 minutes as they get their food and bring it back. We'll let the alternates do the same thing, and then we'll press on.
Yes, sir.
Does that work?
Perfect.
All right. You let them know.
1 o'clock, Michael. Thank you. See you at 1. All right. Good luck.
Thank you.
I'm gonna go grab some food. And try to get back into this room. Did the deputies come tell these people?
The people that went, the gallery, oh, no, he's gonna come get.
Okay. If you see the deputy, make sure he comes and he tells us to.
That's right.
I like you.
No. I understand, yeah, you're just looking out for the two of them, so.
I don't see the deputy.
I think he went to get them.
Oh, he's gonna do them first. There it is. Okay. Thank you. Are we gonna be able to get back in early or not? Yeah. It'll be, 10 minutes early? Yeah. I'll wait for you in the hallway. Thanks, Debbie.
Yes, sir.
Oh.
Now, one of the news agencies is called Michigan Free Phone. And I just did the math on it. He's up by 83,000 votes. And there's 55,000 outstanding. So even if she gets 120% of those votes, she's still going to, hopefully she won't get 120%. But that pretty much seals it. I mean, it was sealed before, but he swept the blue wall, man.
Fast,
So what?
fast.
And I was just reading about it. And they're saying that in Pennsylvania, you got 23 to 25% of the applicants. Pennsylvania. That's unheard of. In the moment, it's in the single digits or the low teens. 8 to 12%. Even 23 is still what I saw. That's incredible. But he won Pennsylvania by 150,000. They just called it 58. It's just like you saw my defense, it was crummy, but his defense
It's the notice that the guy is really
that's not. The other part of so long. This last time, so the others make longer. That's the problem. They try to get
And he wanted to go to Eli, and he probably cut off the pants, and so should have found this stuff in it. Comply with the statute. Oh my God. All foster you know, I started to say, what to you? I figured, oh, you shouldn't ask why it took them so long to pick my best. But that's the one thought. Why did it take me 8 hours to pick my charged you everything and sit home everything? I said, just, is there anything I did that you found especially annoying? If I know. That would get my son. Obviously, the rest of the money I just what I did with the here, like in next year. Go this and that. Shut up and start that. That might change. I said, there used to be a process of being favors and
She's good.
oh, she, I don't know how she is now, but at the time she's very person. We had a trial. My God, was 6 felony convictions of ANC recidivists. He's charged with a plethora of charges. One of the charges is kidnapping with vodka. So we do the whole trial, and she's just being fed. Then at the end of the trial, yet not guilty on everything except one. And it's kidnapping one. Because there's only like 7. She doesn't have to. And we think I did the truth. And she starts yelling it out, trying to get it not kids to together. No, I want to know why they didn't convict on all of them, just yelling at her. To the point to where the judge had to come and get the jury to physically pull her out of it. Because he was trying to get her, she would have been so finally grabbed her by the arm and trying to go back to the jury. But she was yelling at the jury. Her quitting on 5 days after she got in. It was for your time, it was T. Jackson. He had a good fish around. She was so mad. Hey, I'm not doing that. That life without it. I was like, it's like all the goodness, like boom, I was just showing you the last time. We had that case of when that was also in your, it was the hitman from other case. Co-owned a car dealership with his girlfriend about 20%. She dumped him and had a new hand. He's trying to get her to get back. She told me she's got it. So now they're having to split up the car dealership. Cheaper. And they were trying to kill her. And she wanted to give her the birth share to basically end the partnership. You have to buy her out. My guy
It's a bully. He got life looking out. That would be. That it very thick for sporting services. I've had three trials there, two completely locals. Road trip. That's a good track. But actually doing a decent job. You know, trying to ship this. And on the day before, I find that's an excursion. I find this will be a trip. Regarding this trial, of course, thankfully the judge let me off the case. Because he'd been threatening me and cussing me in Spanish nonstop ever since I took it. Such is my life. CNN just called me shooting to from Trump. Not like. So the map is going to end up exactly the same, with possible exception of the bottom. God, I just can't believe shit. We got 66 million votes. That's just. I think people just stayed home, but then switched to Trump because he got 4 votes too. Just like me, 7. So you should set it out. I voted last Tuesday. Yeah, I'm a libertarian. I voted for Clinton, Obama. Obama won. I didn't vote Obama too. Both Clintons. I go back and forth. Haven't seen you in a minute. It's Abigail, right? Yeah. Hi, Abigail. Doesn't need reinforcements.
Right, since I thought we were the only ones here today.
Okay.
We just had a hearing to set aside the young. We went up.
Call that Walt.
I haven't seen you since you took your new gig.
Yeah, Fulton contacted me and asked me if I could pick up a handful of cases.
Yeah.
Through Fulton County, not in Chickens. And I said I would do it. A number of firms. Drinking or smoking do that. Something that carry my judgment.
Right, like a couple cases turned into a lot of cases, yeah.
For 2 years.
Right.
And I've got, after this one, I've got one more left with, just really big, so. And I'm like, these, I would say it's gonna make a decent offer. Call them, tell them to make the offer. Here, I have a final exam on December 3rd. I have a term that was treatment around December 5.
You're getting a PhD?
They're trying to make me go to trial on December 2. I'm like, I can't.
This is how you get out of Fulton County.
Well, I'm in Cobb and Gwinnett now. You know, what to because there you go, associated. For all, I have 200 cases in Cobb and Gwinnett. But when Fulton wanted, they were like, you know, I had your cases. And the problem was we could never get them to go to trial because the like every 6 months, they get a new lawyer, right when the new lawyer is getting ready for trial, they change it. Like a shell.
But I think back on it, if I knew now, back then when we had that case, that would have been such a fun trial. That's the one where he stole like 20 cars,
Oh, yeah, from the
the auction plot, the,
auto time or.
yeah,
Manhunt,
yes.
But I don't do trials because they're fun. I do trials because I don't have a choice.
Right, I mean, there's some guilty see.
Most of them.
They were really guilty, and I got talked into that. There was some circumstantial case, and we didn't have a lot of evidence. But looking back on it, yeah, I know, looking back on it, I'm like, what? And then all this like sexy cars.
Did you get a conviction?
Yeah, we did.
And did you get a sentence?
What did we do, 7 years?
You got prison.
7 years?
What do you want, death penalty? What would you looking for? 40, 80, 200?
I mean, probably wouldn't have given him much more.
I thought you got a fair outcome.
Yeah,
And didn't have to squander taxpayer money.
did not.
But I never do trial because I think it's gonna be fun. I do it because I'm in a box. I'm in one.
Oh, short. Right, yeah.
And I'm a tax. Think of how much money was spent on last night. I would love to see that on.
I think a lot of people would. But and even including security, including jail transportation.
No more jail, that time served. I do understand there are cases that have to be tried.
Yeah.
Like the one against that has to be
What
tried.
is that?
That has to be. That's what it wants.
And oh, wow, okay. So y'all had a big week, I had a big week.
All over the place, but where's?
You sat with you, Julian.
It was long.
Okay, so she's just hopping back and forth?
But see, there were cases that had to be tried.
Yeah.
There were cases that should be tried, immigration cases.
No, I'm good. I'm like, I don't get it.
Because it's cars from an auction lot, it's
With
not
the-
a case that has
With
to
the,
be tried.
Julie, these guys stole like 15 cars.
More.
So
30.
was it like, okay, with machine guns?
Yeah.
It was like AK-47.
They took command of the entire lot. They abducted, but
I mean,
Tied up.
there's probably like 10 of them that came from the back.
10, 20 or so.
See, now I hear a lot more facts than I did know.
They
But,
took 30 cars. How would we drop, we got like a remote control.
Right, yeah.
So like
It's, you know,
30 or
there's-
40 guys descend on the things.
There was a theory that it was an inside job,
Yes,
that the,
it was.
it was,
I know for a fact.
so they knew the security guard?
That's what they said.
So the security guard was like, oh,
I was scared.
I'm so scared.
Yeah. Oh, on the video.
Yeah, I'll
Oh
press
my-
the
oh my
button.
God.
Yeah.
They tied him up. And, but they were never able to prove the security guards. Yeah, there was, so they just raced out 30 cars.
But then, they had the security guard's phone pinged a mile away.
Yeah.
And what would you know? Like this trucker is just bringing in cars. There's like 20 cars in a front yard, all brand new cars. Like, what did you? They should have had a plan to hide them.
They should have.
Yeah, they were not very smart.
They didn't think about the
What are we gonna do with
the
them?
parts.
All they thought about is, we're gonna get them. And now what do we do? Oh my God, what do we do with all these companies? But I thought you got a fair outcome. I thought you got a conviction
Yeah.
and you got prison. Maybe not as much prison as you wanted, but part of the game.
Well, and you know, the thing with Whitaker, well, at least when I was in the trial division attorney case, in her, courtroom, I feel like maybe her mentality is people are either not rehabilitative or they are. And she doesn't like those like 7, 8, 9 year sentences, because that just makes people, it doesn't ruin their life, but then when they come out, they're just worse than they were when they came in. So like, let's just do a couple months, or let's do life, but let's not.
Yeah,
I mean, that's kind of the vibe I got.
I don't think you would have pled to life on that.
Right. She may not have given her stuff. Well, I mean, she couldn't have gone looking for minimum, but.
Or maybe there was a kidnapping charge the other day. Possibly life, if they thumped him, but I don't think they thumped him because he was part of it. Okay, we're gonna pretend to bust you in the head with the butt of a knife. Pretend like it hurts.
You should have told me that
I put some
afterwards.
makeup
You
on.
should have been like, damn, you did a great job, but
I shouldn't even have told you now.
either way, they knew the security guard.
That's my understanding. That's my understanding. But I could, I read cases a lot and I say, oh, yeah, they will look at it.
Did,
We had a case up in, Gwinnett, where the son actually lets my client and his friend into the parents' house and lets them steal all the stuff. And then when the parents get home, says, oh, I was kidnapped. And then they go, the police get his cell phone and there's all these communications between him and my client for weeks in advance of the home invasion, setting it up. And he's got it on his cell phone when he communicated with my client, planning the home invasion. My client's charged with armed robbery, kidnapping, theft by taking. And the son, like the parents whose house was invaded, as a juvenile case. Because the Fulton Gwinnett County Police and DA replied. We were at the prelim telling them the son set it up. The son said, they say, all right, we'll look into that. Sure.
okay,
And then they got his phone. And they're all, they got the son's phone and they're all, so they didn't have to say another word. I just saw the guy, oh, give it a deal. He's getting 10 sort of 3 instead of 5 sort of 20 sort of whatever, with 3's rules. Because they figured out that the son was involved in it. That's a good thing.
And they, like, the superintendent got the job there for that, or was it that they? Or that they like that to
My understanding, everything I know, is that the school votes. That's not my job. But I thought you got a fair outcome. You got a conviction and you got prison time. And most of the cars were getting.
Oh, what was the co-defendant never arrested or he was on the run?
He was on the run.
It was like a bench warrant.
You got what you need. I once again, I just think that only a few handful of cases. The rest of it should work out. If it's not, should walk the way it's stabbing, it's not, should not the way. It's both sides of the really one advocate. Read it.
One of those is one.
Oh, really? Well, you never argued
Domestic violence.
I have a domestic violence I was talking to him about. County. But back in that service. So the girlfriend's nagging the heck out of the boyfriend. I'm so slaps his twig at his head. That's on it, so he's punching, but this is the victim stage. Find it out. He stands up here. Also, I wasn't doing anything wrong. This stood up and punched me for no reason. Only possibly we do that. Boy, the guy's just sitting there and he drove over their mind from business. So it's the only prosecutor would do that. But the police and the prosecutor, it's a big charge of being arrested. The girlfriend has now filed back with her for this. She just sent an email. She sent an email to the prosecutor, and the prosecutor's basically saying, "Do not ever contact me again. If you contact me, you're not going to call me." So that's the two. The solicitor who's filed an affidavit, so she starts blowing up. She's blowing me up, no, there's nothing I can do. So we had a bond at magistrate court, and it's the bond status. For the night, when the day before the hearing. If I show up for the bond, I'm sitting there, they call it calendar, and I'm sitting there, and then, all right, Mr. Shepard, we'll give your bond and everything. But for the first time ever, the solicitor says, "Oh, no, you don't have jurisdiction." Or we have accused it. I said, "When did you accuse me?" He said, "Yes." You didn't tell me?
Okay, I should, hop on TV. Yeah, okay, perfect. So it's at 1:30, right?
I don't know
guess I
what you're
can't-
talking
I
about.
guess I can't come back on the jury room.
No, there's a jury back.
Oh,
Go back there and see if you can cast a vote. So just to finish it up. So we continue it.
Yeah.
You could have told me this for 2 hours. Not that big portion.
Okay.
Her minions.
Yeah.
So you people start blowing up the judge. I didn't have a bond. Why didn't you? And I filed a bond motion and said it.
Yeah.
So I've had a bond motion pending for a month.
Yeah.
So the judge says, "Hey, we can schedule this for a bond hearing or state consent to a bond." It's a misdemeanor. One punch to the nose.
Yeah.
$45,000. On it.
It's a big punch. It's a big punch.
Did it break your nose?
No.
Oh, okay, good.
Anyways, good luck.
All right, thanks, guys. Yeah, you, Julie, good luck.
Yeah,
Where do you go? It's a freshman. You have the office?
No, I can't. It says do not enter.
Yeah, they're jurors.
Um,
Jurors.
seriously? Oh.
Am I joking, Julian?
which one?
There are jurors in there.
In there? I thought they were over here.
Oh,
Oh, the two, the alternate.
they're alternates, but they're still jurors.
So sorry.
I didn't want to just bust up in there, the church.
You're right, that's what I'm going.
She's like, "Who are you?" Yeah, I heard him go back then. Yeah, that case I had with her, she had him for dead meat. It took like 7 years. I think sometimes prosecutors get desensitized to the actual impact of a long person, something you can work on. That sometimes you're like passing out 7, 10, 15, 20, right? And things, you know, it's like, oh, it's just a 20. To the person doing the 20, it's, you know, but we get desensitized. Like now, you know, bullet wounds and pictures don't even faze me. Whereas when I first started, you know, oh, how am I supposed to conceive tonight? You know? Oh, well, that's good. Maybe that'll help build the country. Oh, Joe Biden's supposed to speak tonight too, it looks like. Guess I'm gonna be called garbage and the Nazis. I'm a Nazi. It would be nice. Oh, it says it's gonna call me. Oh my God, look at this. This is really hilarious. You see what Joe Biden wanted to go about? Look at the color. I texted, is that really Joe Biden? She was like, yes. So she wore red. Oh, red. At least she doesn't have a red hat on. Oh my God. Yeah, I don't think she likes Kamala. Do I? That's probably. Yeah. I think, you know, she was the one who was pushing Joe to run.
You ready to go?
I'm sure. I'm sorry. Do you think it was on purpose?
But I hope
It was an F-off.
that seems like a story.
Yeah. She was the one who was pushing for Joe not to go out because she loved being first lady. Yeah, she loved it. She were. Oh my God, it's her. There's like 50 news stories about it. Jill was the MAGA red vote. I guess that's the new color. MAGA. Oh, it says in here that Joe Biden declined to attend Kamala's watch party. Not like before the results were.
Or last night.
Yeah, so before the polls closed, he said, I'm not coming to your, what they call a watch party. That's a stop. Maybe there are hard feelings. He didn't actually the race war, not push it. Jill Biden has not gotten over the coup that removed her. That's a Trump vote right there. Sometimes I love the, most times, this is hilarious looking at all these posts about it. Yes. Yes, yes, yes. Look at the judge, when it's a question, we're just guessing.
I say, I know that other portfolios, if it's left,
The way it's question, where it is.
well, some portfolios, you want left.
Okay, so you think it's a question. We're about 4 hours behind schedule. You know what I mean? We're a couple of citizens. We listen to you. I might just ask you that. I just have a listen. We would have a motion to suppress. Remember who's saying the order. I think right there, we asked.
Was in that motion, it's very brief, but I believe, you know,
I think he asked for the order. And she argued, you know, this is the funniest thing ever. Adrian. So. It's a, he's really wanted to get the confession. And it's actually, it was 2 hours first. Hour, out, he's reflecting the body. Over the second hour, best. The wrong. Right about 45-minute mark. The police officers are disengaged. Disengaged when they went to re-engage, get them back, say something, get on for re-engage. But the way they re-engage is fine. And with the police officers. Well, I will appreciate this. Frankly, how well. As the state meetings, I said, it's like, I'm done talking. I want to, fuck you, I'm done talking. I want to. The talk just keeps going. People sit there left and right, dude. Gets him to confessing. We have a police arrest. We actually had to spend about 20 minutes. At one, Adrian McBurney's case that is at an invocation for a request to remain silent or a request for a lawyer is only effective. It's not in minutes. After about 10 minutes, she argued with Judge Dover that fuck you, I'm done talking, I want a lawyer is ambiguous. We cannot say for certain what he meant when he said. Like, she's going back and forth with Judge Dover, so I pull out Dover's judge. And this fabulous book that you wrote. And of course he granted. Remember I told you I'd let him go to trial before. Yeah, actually won 2 on the trial. So we were able to suppress the statement had. So they played part of everything they could. The jury has to take the statement again during deliberations. And Judge Dover plays it and stop it. And then the juror says, no, we want to hear the whole interview. He says, what do you mean? He said, the little bar thing is only about a third of the way across the bottom. We want to hear what's next. Of course, they couldn't hear it. They quit it. But they could see that the little thing fell.
Sometimes I'm amazed, sometimes I don't think it's protection all enough to because they don't even think the folks.
It's like the if they ask, I'm going to get my client.
Okay.
But if that is what they want, now is a good time because It's like they're not asking those in an hour before you're in interview at 4:30. So that's what it is.
Okay. Oh.
Well, the Democrats won the Wisconsin Senate race, but that was expected. That Tammy Baldwin's been their senator for a while. Slotkin, Democrat, is still running Michigan with 3% out. He was in the House and then she ran for the Senate. Republicans are barely holding on to Michigan with 3% votes. About 35,000 could lead. That one could flip. Bot is still 1,000. I think the Democrats have been like Arizona basically. Oh, so that's something. Hold on. Fox News has more votes. And now it looks like the Republican is up by about 1,300 votes in the Super. With 98.96%. Yeah, they have more current data than CNN. The Republican is still up. 33,000 votes. Arizona is the guy's up by 60,000 votes, the Democrat. And in Arizona, the Republicans now up by 6,000. I'm sorry, I won't look this up. I do a lot of studying on the House and the Senate.
Walk on the water, man, see it?
All right. Good afternoon, everyone. Let's get on the record. In State versus Reynolds, Mr. Reynolds is seated at the defense table with his lawyer, Mr. Shepard. We have Mr. Jordan here for the state. And we have, it's interesting, it's numbered 1, 2, and 7 and 8, but it's 3 questions from the jury. I'll read them into the record, and then we can discuss possible answers. Question 1. Does the aggravated battery charge, part 2, page 9 of the jury charge, apply to the ribs only or to other organs as well? The indictment, count 7, mentions ribs. Does the aggravated battery charge, part 2, page 9 of the jury charge, apply to the ribs only or to other organs as well? The indictment, count 7, mentions ribs.
Ribs only.
We'll get to it. Question 2. For aggravated assault, how is an object defined? Does it include a body part? Page 9 of jury charge. For aggravated assault, how is an object defined? Does it include a body part? Page 9 of jury charge. And the third one that is actually labeled 7 and 8 says, can you please define intent regarding count 1, murder? Can the degree of force be factored into intent? Can you please define intent regarding count 1, murder? Can the degree of force be factored into intent? So, for the first question about aggravated battery, I'm inclined to go along with something similar to what Mr. Shepard said. I'll come up with some wording and run it by you all, but it's the indictment that controls and not other things. And so it will be words to the effect of count 7 alleges aggravated battery to the ribs and the ribs only. Something like that. Mr. Jordan, any issue with, I'll fine tune the language and run it by you for a final read, but I think I'm aligned with Mr. Shepard. What's your view on that question about aggravated battery?
I believe, Your Honor, because the indictment specifically alleges that the ribs, there was a depriving of the ribs, that would be the correct way forward.
Okay, I'll probably even say limited to. I don't want them to think like, well, all right, we know it says ribs, but we're going to think about the internal organs. As for aggravated assault, it was 2 questions. I think we really just need to answer the second one. How is an object defined? Question mark. Does it include a body part? Question mark. And I think the answer is object can include a body part.
No objection from the state, Your Honor.
Didn't we define object in the charge?
We did, and let me put it on the screen. But I think, and I think it says object is anything that could cause an injury, words to that effect. Let me get it on the,
Just reread the charge, because the charge answers the question.
okay. Let's see what it says.
I mean, to me, the first question is a question about the law, and that is, are we constrained to the wording of the indictment or not? And the answer is yes.
Right,
Can't find that he deprived her of her left eye and convict when the indictment says rip.
correct.
But this is a question of the law, and the law answers the question. And I think it just regards along the law.
Oops, wrong case. That's interesting. There we go. All right, on your screen should be aggravated assault.
First knocked out.
Oh, I'm sorry. Let's see.
I don't need a, okay, a person indicts. I thought we had something about describing.
The last sentence, language, but we didn't have a specific definition of object.
I guess what I propose saying, object includes anything that is likely to result in serious bodily injury when used offensively against a person. So not saying yes, it is, because there may be a juror who right now is thinking there is no way a hand when used offensively against a person could result in serious bodily injury because it's a slap or something like that. I don't want to convince them otherwise. That's their call to make. But it is, one, consistent with the charge, and two, responsive to their question, which is what I'm more focused on, to say object includes anything that you conclude would result in serious bodily injury when used offensively against a person. And then they need to decide, does that include a body part or not?
I think that is more appropriate.
Than just saying yes. Okay. That works for you, Mr. Jordan?
Yes, Your Honor.
Okay. The last one has to do with murder and intent. And again, the question was, can you please define intent regarding count one murder? Can the degree of force be factored into intent?
I think you just have to recharge on whether it's in the, and that's their job to struggle through and with what they're charged with. I know we define criminal intent in the charge.
Right, but criminal intent is simply the intent to do the act that is prohibited by the law.
I think you recharge on that and murder.
So I'm not inclined to bring them out here and read it again. What I would do if I end up agreeing with you would say you should reread the charge on murder. They can do it. Me saying the words won't be any more meaningful than them reading it. And so I may do that. I'll give the page reference, the charge that starts on page 7 and goes to page 8. I'm just wondering if I can appropriately give them a little bit more. That's just what I'm struggling with right now. Do you have any thoughts, Mr. Jordan?
I may have one brief second.
Okay, you're consulting?
Yes.
Okay. I'm going to start working on the others.
Are you proposing to do a written response?
Yes, my preference is in general for all of these, it's to write something on the back of the card. And that's what goes back to them.
I think that would be a great way to move forward. Depending on what the state comes up with for question number 7, question number 8.
Okay.
So what happened to breathe through things?
Juries work in mysterious ways.
And
Are you just bringing out the deliberating jurors or are you bringing everybody?
So I'm not bringing anyone out. I'm writing this down and then Deputy Gordon brings it back to them. And we return to whatever we've been doing.
Understand, thank you.
Hmm?
I can step outside briefly,
Everything all right?
Yes, I just want
It's
to.
gonna call appeals.
Okay.
They don't got Mark Mallon over there still.
Mr. Jordan, any thoughts on that question about the degree of force being factored into intent?
Your Honor, I believe that the degree of force would go more to the malice than anything else and not the intent portion. So I do think that at this point, pointing the jury to rereading the specific language within the charge for murder is the most appropriate direction to go forward in because it does specifically lay out malice. And I do believe that the state, even though of course we can't give them the closing PowerPoint again, but we spoke to them about the degree of force being part of malice.
Okay. Malice and intent are really the same thing. So when you say this deals with malice and not intent, I'm a little confused. But when we're in murder, malice is the awkward way in which the legislature and higher courts have decided, well, it's the legislature because it's in the way that murder is defined. Malice is the intent in murder. It's the unlawful intent to kill. So it's not an accidental thing. If it's accidental, then it's not murder. But that it also isn't, it's what's the difference between felony murder and that may be what they're wrestling with. I didn't mean to kill the person. I meant to hit the person, but I didn't ever think the person would die. If they died as a result, that could be felony murder. And I think what this jury is wrestling with is, well, how hard you hit them? If you hit them real softly, then it is a credible defense, not the defense raised in this case, that, yeah, I hit him, but it was so soft. I didn't mean for anything to happen. And doesn't seem like these were soft blows, given the damage that we saw to Mackenzie. And that's probably what they're grappling with. But I think it's cleaner to suggest that they reread the instruction for murder on page 7 and 8. Any objection to that?
No objection.
No objection.
All right. All right. The question about aggravated battery and ribs or other organs, I have written, your consideration is limited to what is charged in the indictment. Any objection to that? Mr. Shepherd.
I think you have to say what is charged in the indictment, ribs.
That is what's charged in the indictment.
I would just ask that you specify that the indictment is limited to ribs.
Okay. Anything, you all right with this?
I would rather what Your Honor proposed rather than saying specifically ribs, because the indictment does speak for itself in this case. Your Honor. And
All right.
as to aggravated battery.
The aggravated assault question, I wrote, object is anything which, when used offensively against a person, is likely to result in serious bodily injury, which is almost word for word what's in the jury charge, but rather than saying, go read it again, I wrote it out for them. Any issue with that?
That's a correct statement of the law.
Okay, Mr. Jordan?
No objection from the state.
All right, and finally, this question about intent and murder and degree of force, I wrote, the charge on murder on pages 7 to 8 addresses this question. Not a particularly satisfying answer, but I mean, other than bringing them out here and reading it to them, which is doing the same thing, I think that is where we are with that. Do you agree, Mr. Shepherd?
I agree with that one. Can we read the question number 1 again? But I do agree with that one. And
Sure.
I agree with number 2.
All right, I'll come back to it in a minute. You okay with the response to question 3/7 and 8?
No objection.
All right. Question 1, which says, does aggravated battery apply to ribs only or to other organs? The indictment, count 7, mentions ribs. I wrote, your consideration is limited to what is charged in the indictment. Mr. Jordan has said that's fine. You want the word ribs sort of woven in there.
Go with this to the body parts that are specifically listed in the indictment. It's limited to the body parts that are specifically listed in the indictment.
Okay. I'm gonna leave it as is because I think it's interchangeable. What is charged, the body parts that are charged, and as you pointed out, Mr. Shepherd, there's nothing about internal organs in the indictment. So if they're limited to the indictment, they are straying away from it if they're thinking about something that is not ribs. It's ribs either deprived of or rendered useless. Thank you. Either one seemed to make sense. That was my agenda. Thank you. All right, we will be at ease again until Deputy Gordon tells us there's more. Did the light go on when there were questions? That's how we knew? Good, they learned how to use that. I will take the jury charge down.
All right, be back.
I think we'll have to further this afternoon. Congratulations.
That's when you go, it's really big. That's when you learn, yes, they do that, it's
I always remember that I am so trained, because I was in this building, I was the main C3 for this building from 08 to basically 2020. And the COVID hit. When I went out of courtrooms, I just instinctively grabbed it and like there was no thing that. Because some of the judges had the doors taken out because they don't like the doors. Yeah, it's just a long way. But that definitely means that he's getting those questions. That means they have decided that now they're just trying to figure out which ones is good, which ones. Yeah, they would be asking those questions. Say, we get to it, what is this? Not unexpected for me. It would have had a jury pretty really here. The verdict, I hope I never heard of it. Because they've already decided he's the one who caused the case. Now it's just what if these crimes is he guilty of? I'm not going for the long. It's selfish stuff. I've got 15 cases about coming tomorrow. Oh, I got my income tax refund. I'm thinking I'm gonna buy a boat. See how much? $6.
I thought that there was other digits.
$6.57. Oh, yeah. Oh, 37 cents. $6.30. Oh, I might go get a Wendy, but I couldn't do the combo. I'd have to just do the sandwiches. No drink, no fries. But it's a lot better than owing the money.
Yeah, that's actually time.
You did? You married?
Yes. Wife would Friday, yeah.
God. But they weren't withholding.
Oh, here.
So this is my conflict letter for tomorrow. I know this is today, yesterday's not. There's a deal warrant. It's all calm, and folded together, folded for judgment money and all calm. That's today. That's today.
Today's the same today.
Yeah, this is tomorrow. It starts there. That's not too bad. It was, oh, it's Gwinnett. And then Cobb. So what I do is I'll go to Gwinnett first, do my little whatever Gwinnett will head for Cobb, and then I got Cobb in the morning and the afternoon. And it's the same two judges. I've got one courtroom in Gwinnett, two courtrooms in Cobb, which is. Does your Monday look like this? They gave you Veterans Day off? Just gonna work from home, right?
Yeah, because I think I'll have enough time on the 18th, so.
I'll be home working. I won't be wearing this. So you said your wife is an attorney?
Yes.
Oh, that's
She's
fabulous.
at, like, right now.
Did you meet? Oh, you met her through,
Mr. Brad, Terrence Brad.
yeah.
We were both solicitors out of town. And she went to Clayton. She's been in Clayton since. Yeah. We applied for the actually. Back to Clayton, get a years. Motions, they have one going. Well,
So she went, wife is her living in that back. A lot of people do.
Yeah.
All the prosecutors will try private for getting it.
That's not, that's. They family dollars for like, oh, I got this all.
His husband's in counsel, he's going to each other. I just don't understand how they can what's be that hateful to the other one.
It'd be the pettiest thing in the world. It was a small farm that I was working in, but I used to have to tell my mother, he says, that's the next thing I tell you. I'll figure it out, just everybody. Or child with a friend, talk. Because I can see it fall honestly. Probably it is. That makes it's like you can get me going. I'm gonna talk to 3 hours, you know, it's why, everything challenges the get your bill versus box.
I had one client, she was so petty that I had to cover up his fire between. Let me file a contempt motion. Because, he was supposed to meet her to pick up the child, I should have gone on this. I asked for a younger.
Yeah.
I forgot that. It was 20 minutes late, going to pick up the child on Friday. 6 p.m. I think it was Friday and Christmas was like the next night. They've been out on from the mall week before Christmas. She wanted me to put it in contempt action, they showed up great attention. About her basically not get paid, sure, to go back. But the baby just got stuck in traffic. He did it on purpose, he should have let me not like this. I'm not gonna be filing motions, finish the divorce. The divorce is finalized. What you hired me to do is complete. If you want to file any type of petty contempt motions going forward without. Not just for sitting with it, kind. 20 minutes. You want the judge to go to jail? At Christmas? I understand. The other voters I will deal with extremely unprecedented. It's vicious and doing your child support calculation in their life. Well, in addition to that calculated show, we do an extra blank. Because it puts the legal basis for you. Be able to type it. Calculator of those. Right, of the theme to you. That God's law or freedom. And they're just always trying to chisel an extra 5 million, an extra 1,000. And like, listen, it's a calculator. Excel capability. I understand you don't like it, but it's all Excel. Well, whoever you work with. We just had all this. All the people in this situation where the opposing party is the financially brilliant party. They were always asking for your attorney to pay for their attorney fees. And they would file these completely ridiculous motions that they're going to lose. And they said, no, we're going to ask for attorney fees. They're going to have to pay some million consent. Or he's going to have to pay for all attorney fees. They'll get their others. Which you just find yourself focus on the past service. And it really did. We need extra sitting for get more money out of their account. Get running up their game necessarily. Their father is going to tell you honestly. I would very much very sympathetic practice. This is good for it starts happening now. Where do you go?
Good Lord, good case, congratulations.
We'll say the acceptance
We'll
when
talk to people about their VIPs or VI.
I would always think it's like, it was
Not the jury. Yeah. Oh, those questions are, there's no doubt there.
I think Lauren is.
Okay.
But I'll definitely.
Because I would like to, try to leave at a decent hours. Or are you thinking you're gonna ask the judge to let us come back?
No, I wouldn't ask for like anything, so just want to find
Wrap it up today?
I would just ask for every other 15 recess.
But yes,
I would ask for every if.
I'm down for whatever you want to do. I prefer to wrap it up today. Because
What's mine is not gonna
if the state has a desire to come back another day, I'm not gonna object. I would prefer to do it today. Those questions, these are clear. That they get he's possibly I figure out what he's supposed to have when it's done. Ready to roll.
I'll go see if I can find me something liquid. And, no, I don't know, I think it'll be a couple of minutes. They think they gotta fill the form out.
Oh, you are not. That's right, it's been fast.
Oh, where did you go?
Like, you're the top.
Yeah, hers.
Here's another yellow light,
What?
another yellow light.
Oh. Did I come back in time or have they been looking for me?
No, there. Yeah, but
Back in somehow. I ate in the little food court, they go teriyaki chicken. And I think it's what university. Bison. And like Asian. Did I do something that's been bothering you all morning?
what's that?
Your thing was hanging half off the table.
Where is it?
This thing right here.
Oh, that didn't, that's good.
If it gets nudged, it's gonna fall on. So what's it? I see it and it had fallen and broken. Back, I had said something. That way it's just less likely to fall over. I'm weird like that. If I see something and they don't intercede and then it breaks or, you know, I'm like, I just want to introduce that I saw in the news. More questions? So everybody's in Douglas County is very snotty to me. You know, the public defender out there. You're supposed to stay on the case until it's closed. Because I thought when we get pretrial diversion closed, I submitted the invoice, you paid the invoice, you're gonna start your new invoice. You know, I can't help it that bailed out of, it's like probation. You know, Fulton County still tries me to get to show up for probation revocations for 2010. But and I put it in this email, I mean, I'm not appointed for the rest of my life. You know, a plea or entering pretrial diversion closes the case, that's the end of it, if you, because many people complete pretrial and there's no additional work. Many people complete their probation and there's no additional work, so you submit your invoice. If the guy gets 20 years of probation, we're supposed to wait 20 years to submit my invoice. It's not when the probation ends, it's how the case closes. Do we have a verdict? Do we have a verdict?
I think I was coming through, Mr.
Oh, I apologize. Thought maybe you knew. So you heard me tell my client if verdict is going to be rendered, there's no gas here in the courtroom. Don't worry, so there's 6 deputies standing right behind you. Oh, here's deputy number 3. Look. See? 3 more to go. Because they always know the ratings. You start getting ready. Diet. Oh, let me see.
Follow walk.
Yeah. What's your name, deputy? What up?
It's on.
Court come to order, remain seated.
Ms. Rivers, are you ready? Excuse me. We're going to get back on the record in State versus Reynolds. Mr. Reynolds is here with Mr. Shepard. We have both prosecutors here. And Deputy Gordon tells me we have a verdict. Ms. McCauley, good afternoon. Anything we need to talk about before I bring the jury out?
No, Judge. I'm just on loan very briefly from AC.
Okay, well, we'll take you while we can have you. Mr. Shepard, anything we need to cover before the jury comes out?
No, Your Honor.
All right, let's bring the jurors, please.
All right, adjourned.
The alternate should not be out here right now.
Yeah, go ahead.
All right, everyone can be seated. Excuse me. Ladies and gentlemen, Deputy Gordon tells me that the jury has reached a verdict. You're holding the verdict form. Can I assume you're the foreperson?
Yes.
Could you hand that to Deputy Gordon?
Sir.
I need you to stand for a sec. I have a few questions for you. Did the jury reach a verdict?
Yes, they did.
And was it a unanimous verdict?
It was unanimous.
Have you completed the jury verdict form to reflect whatever agreement the jury reached?
I did.
All right. I would ask you then to publish or read the verdict into the record. You don't have to start at the top of the page, just count one, whatever the finding is, all the way through count 7, please.
Okay. Count 1, murder. We find the defendant not guilty. Count 2, felony murder, cruelty to children. We find the defendant guilty. Count 3, felony murder, aggravated assaults. We find the defendant guilty. Count 4, felony murder, aggravated battery. We find the defendant not guilty. Count 5, cruelty to children. We find the defendant guilty. Count 6, aggravated assault. We find the defendant guilty. Count 7, aggravated battery. We find the defendant not guilty.
Thank you. Deputy Gordon, if you would please share that verdict with Ms. McCauley and Mr. Shepherd. Ms. McCauley, do you have any objection to the form of the verdict?
No, I do not.
No objection.
Okay. Ms. McCauley, anything else from the state before I release the jury?
No, Your Honor, other than my appreciation. Thank you very much for your service. May I be excused to return to 8C?
You may.
Thank you so much.
Mr. Shepherd, anything else from the jury or from me before I release the jury?
I would also like to thank the jury for your service and for being a great group of jurors. Thank you. However, I would like to poll them if I could.
You may. Actually, I will, at your request. Ladies and gentlemen, I will be asking each of you when I call your name. If you would stand, I'm going to ask each of you the same 3 questions. Juror 1, Ms. Martz. Was the verdict just read into the record, your verdict in the jury room?
Yes,
Did you freely and voluntarily enter into it?
yes,
Is it still your verdict?
yes,
Thank you. Juror 2, Ms. Newton. Was the verdict read here or your verdict in the jury room?
yes,
And did you freely and voluntarily join in that?
yes,
Does it remain your verdict?
yes,
Thank you. Mr. Fowler, number 3. Was the verdict read here, your verdict in the jury room?
Yes.
And did you freely and voluntarily enter into it?
Yes.
Is it still your verdict?
Yes.
Thank you. Number 4, Mr. Wood. Was the verdict read here, your verdict back in the jury room?
Yes.
And did you freely and voluntarily enter into that?
Yes.
Does it remain your verdict?
Yes.
Thank you. Number 9, juror 5, Ms. Watson. Was the verdict read here or your verdict in the jury room?
yes, Your Honor,
Did you freely and voluntarily enter into it?
yes, Your Honor,
Is it still your verdict?
yes, Your Honor,
Thank you. Juror 6, Mr. Karp. Was the verdict read here in court, your verdict back in the jury room?
Yes.
Is that something you freely and voluntarily entered into?
Yes.
Does it remain your verdict?
Yes.
Thank you, sir. Number 7, Mr. Duncan. Was the verdict you just read here your verdict in the jury room?
Yes,
And did you freely and voluntarily enter into it?
yes,
Is it still your verdict?
yes,
Thank you. Number 8, Ms. Shaw. Was the verdict we just heard here in court your verdict back in the jury room?
Yes,
Did you freely and voluntarily enter into it?
yes,
Is it still your verdict?
yes.
Thank you, ma'am. Number 9, Mr. Tischler. Was the verdict read in court your verdict in the jury room?
yes,
Did you freely and voluntarily enter into it?
yes,
Is it still your verdict?
yes,
Thank you, sir. Number 10, Mr. Vassar. The verdict here in court, was that your verdict back in the jury room? Did you freely and voluntarily enter into it? Still your verdict?
Yes, Your Honor.
Thank you. Number 11, Mr. Possert. Doctor, was the verdict read here in court your verdict in the jury room?
yes,
Did you freely and voluntarily enter into it?
yes,
Does it remain your verdict? Thank you. And finally, Ms. Roberts. Was the verdict read in court your verdict in the jury room?
Yes.
Is that something you freely and voluntarily entered into?
Yes.
Is it still your verdict?
It is.
All right, thank you, ma'am. Ladies and gentlemen, I'm going to repeat something that Ms. McCauley said just before she ran out of here and Mr. Shepard said, and that is to thank you for your service. This was a very difficult case. It was a very important case. It's been around far too long without resolution, but it has a resolution now because of the time you gave and the attention you gave to it. And we are all appreciative of that. I'm going to have you retire to the jury room. I'll be back there in a minute to thank you further and discuss a couple other things with you. And then you will be free to go. And we'll reunite you with your electronic devices. Thank you.
All rounds observed.
And alternates, you should grab your stuff and go back there. Great. Everyone else can be seated. Mr. Jordan, is there any reason why, after I excuse the jurors, we can't handle sentencing today?
Your Honor, if I may just have a brief 10-minute recess to speak with the family in regards to victim impact statements, but after that, we should be ready to proceed, Your Honor.
That'll overlap nicely. I'll need a few minutes with the jurors, but you're prepared to go forward today.
Yes, Your Honor.
All right, Mr. Shepard, same question.
Yeah, we are prepared to move forward and we understand the state needs a few minutes to get ready and we understand you need a few minutes. So a 10-minute, whatever.
Okay, Mr. Reynolds, you're going to go with the deputy. Well, you're going to come back, but go ahead and ask. But
I know my mom tried to my mom loved me.
your mother what?
And she loved me.
So I'm going to let you talk with the deputies. Right now, you're going to go back into lockup. You'll be back out for sentencing and we can explore that, okay? All right. Thank you.
Let me come on.
You know.
I wonder, which one is this? AA, maybe they sometimes it worked on Monday, but then the rest of the week didn't work. So let me out.
Your card?
Yeah, it let me in.
It's we lost 2 or maybe 7. But I mean, 2 or 3 others had 4. I think that's not good. We have a call river. So we get 5. I'm working, my goals, take 20. That's only the set right. You're going to get 4 rows. Well, it's take 20 goal, it was 4 all the 13 years.
But he innocent enough, you should take a 20, take 20
Yes,
years.
on this act, yes. Yes. The Lord will move the child home 2 hours later. And yes, I was thinking to take a look at these all the time when they're doing this. It's their little good trick jurors. Innocent people that look, take a few of their bonds, to quickly guilty. Innocent people get convicted in a trial because they trained to do it. You can do this. People don't be happy for a living, don't understand. Try to tell them it doesn't matter. Nobody believes, I said, I thought this was all the time, I do this, so like, well, really, really, you guys took this house. I did my best, I did three, I did two different phone murders, and 3 house. So, right now, we're gonna do everything we can to get a life sentence. I wish you know, that would be did until after the sentence, and you don't want to start running around that judge, getting this judge mad at us before the sentences. But so. Hour, 20 minutes. Possible, please, an hour, 40 minutes.
I know.
Okay. That's a major reason why he got convicted. He did that, made that decision, probably protected for an hour, 40 minutes. That's what got him convicted. Okay? Plus, he lied about going to work. He lied, he did all these things after the child died. That they used to do something. Okay? But he made a lot of bad decisions. Pretty out there with that. And that was in the parts for the bad decisions. So that would be everything I can to get out life with the possibility of parole. Where we can at least get out at some point in the future. The take the plea like that, I said, parole for 30 years.
I thought it was from 2 years.
13, 23. That's when we heard parole will be taken to the outside, parole up to the front. If he ever gets parole, he's a judge to be able to like the power. Gets life, it's more than 30 years. All right, now your lawyer tells them to do something, don't do it. Sometimes they will consequences. I say here all the time, they tell clients what to do, and they, for whatever reason, they have to, they have to do obviously. You can't buy advice, obviously, if you have to get that out. But how do you get them to do that? That is the problem. That's like this, so. For a number of years, for those that you mentioned, there how many times she probably was doing tape, for the person. A lot like. We'll get, so what's gonna happen, I'm gonna file a motion for a new trial. And then we're gonna have to really to do some. Okay. And I will set off the case, and I'll do it on the file to the appellate hearing. Once that way, this difficult to settle.
Is your lawyer really gonna work on the case? I mean, once you kind of know.
I have no idea what the new lawyer is gonna do or not. I worked very hard on this case. Very hard. Okay. But everything I could, I fought tooth and nail with that on me. That's basically the case. It's not doing that. Hey, Julian. Congratulations. I tried to tell Lauren what was about to happen in the long way, and she was, had other things going on. I did say, congratulations, you've won. And it's so funny, because I told her you're gonna lose the malice and the ag battery, but you're gonna win the other.
Always hard to do.
I told her, I told her. I was 100% right. Every single time, so it's hard. Yeah, so I hope it's true, because that's not gonna be.
They're still emotional, so I'm trying to make sure that they take as much time as they need before I figure out who's gonna speak, so I should have an answer first.
I've got probably until about 9 o'clock, which is my bedtime.
Okay.
Just like I told Lauren yesterday, you take every penny you need. If there's gonna be any pressure pushed upon it, it's gonna be coming from another direction.
Right. And I appreciate it.
No, do your job, do your job right.
Thank you.
See, I'm not the evil guy everybody says I am.
I don't find you really good. Whatever that's for.
I bought 2 of these.
Hey.
Can I see him for a minute? Come on, man. Hey, would like fun MMA.
Would you help me though?
Go. You know, as many times as you guys have protected me back then, yeah, I'd jump in the mix.
Okay.
I would jump in the mix and protect you. You know, I've had two guys, not here, but in the building, two. Both times you got to do something, kind of was wrong. You feel how that piece of fear.
I
I'm in the town twice. My clients.
Wait.
Yeah, one time it was a female deputy, she jumped right up in the middle.
I have two clients, was it a jury?
They didn't like what I was telling them.
And what they paid for it,
Oh,
all your public.
well, a form of. I'm a private attorney who takes appointees. I was appointed. So I do private work and then I also take.
Think about it. So you just started to see, right?
But
But I might take cases for free, what is it called?
pro bono,
Yeah.
I was looking for free.
Okay.
That's against my moral argument. But no, I told one of them that the offer was a life and he got all mad at me, charged up. I was back at him and a female executive just jumped up and gave him a hand right there on the chest. Just was like. And I was an inmate, and she just basically stopped the hold, and then he was yelling at her, like, around her. And I think that they got me out. But normally they get mad at the defense attorney for blaming me for, and it's coming from this table. So this table says something. And I go back and tell them, yeah, I still like the other one, and they get mad at me for what they said. Well, they finished.
I don't understand how
If they can't accept that they're responsible for their own situation, and that somebody else has to be responsible for why I'm here and why I'm in this situation, and it's the easiest person to shut all things over. And I can't, if they threaten or attack the deputy, they get a new felon. If you like to attack the deputy, they're a new felon. I'm going to make an attack, I'm not going to charge them.
Are you with?
No. Well, maybe if they killed my cat. But that one guy was wanting to continue as a risk trial, and he said that if the jury was about it. And he told us, I'm gonna kill you right in front of you. I said, great. Sounds good. Let's go. I'm not gonna keep the oven, but people want to read forever. That is life. But yeah, no, I appreciate you guys protecting me. No. Ugh. Right.
So Mr. Chairman, is that song two? I am going to ask the judge if we would be okay with you. Everything in the statement via phone. I'm still in custody and stay on the phone right now. And I think Shaquille Duffy is just going to read a statement.
Okay.
I understand do you have the ability to have her get on the phone? Is she at Rice Street? Is she?
She's on her phone. I don't know if that would mess things up in terms of like if she deliberated, if we had her on speaker. I know the mics, we can put her up to a mic, so it's amplified enough to
I
do.
think as long as it used to podium.
Okay.
My understanding is that's what all the sound goes through that mic.
Yeah.
Maybe just put her on that microphone, but yeah, if she wanted to do it by phone, that's fine. She's the mom, she has an absolute statutory right to participate, obviously, but unless in status affects her rights. No, I think that'd be great. Who's the heck out of it? We coming back and have transparency.
It's spoken for itself.
Okay. Well, the good news for the appellate lawyer is now they won't have to litigate the right over from the aggravated battery.
Yes.
Yeah. So we're not have gone on to 1, 4, or 7.
Yeah.
I would not have.
That's sort of saying.
Oh. That like something I was supposed to give? What did I do? I gave you something.
Yeah, you gave me,
Pass it.
what?
Did I give you some work?
You gave me a tissue paper.
Yes. Yeah, that's the passcode to the stuff.
Oh,
Okay, so he wants you to call his brother and get him an appellate.
well,
Call his brother. And hire an appellate because he's gonna get a poison one, he wants a private one. And that tissue I handed you has the code on it. Do you have it still? Tissue paper?
yeah,
Uh,
I have it in my pocket.
Okay, here's some numbers written on it. That's the passcode to the stuff.
Okay.
Okay. Don't lose it. Oh, come on. Kenneth. Do you think any of the aggravating factors on aggravated assault are present? Do you think it's open to come? That's my understanding.
Yeah, I have count 2, and count 5, and ready to count 2. For count 3, count 6 is pretty. Count 3. I wasn't answering in a second.
Okay. So count 2, we're gonna ask for life without, I'll ask for life. Count 3 will vacate. Count 5 will merge into 2 and count 6 will merge. So what do you think? I don't think that's right.
Count 3.
I think you could ask for 20. Oh.
Yeah.
So what I'm saying,
With the cruelty.
well, the ag assault, only one can merge. because it has to be count two.
Yeah.
Count two would be life or life without. Count three would vacate. Count four is not guilty. Count five would merge into count two, but count six is still out.
Because count three vacates according to. I would just ask for the 20, so,
So concurrent with the life without.
yeah, I would.
But
The plus numbers are like very much relevant.
so, yeah, but I do not think that count six merges because count three has to vacate. It will ask for 20 concurrent, and it'll ask for life. Concurrent. Okay. Yeah, but there's all kinds of aggravating on ag assault now. It's wow, a utility work, assault upon a utility worker, a healthcare worker. It's just a change. It's so just 1 to 20. Also, the court, we do not attack. Central federal. I think it's age of the company like cause of aggravation. Public transit worker. They beat up on the MARTA train with the bus driver. It's going to try. Okay.
So that's.
And my reading of the literature is 5 to 20.
Yes, that's correct.
The life or life without. Vacate. 5 to 20, you want merge. I guess all 1 to 20, 20. And what difference between you be not saying like that doesn't give them a lot of decision making. Now I want I dang teriyaki chicken for me first.
I've never eaten food in 4 years.
Well, the food of place is actually a neat concept that it's every day it's delivered. So it's like the same sequence every week, like Monday is this person every Monday, Tuesday is this person every Tuesday, or if it's like kind of there's variation in this. There was one last week that was good. It was good. One today was, like a Panda Express level teriyaki chicken. You're bringing Panda Express. Stab, which is not good. So, very lucky chicken, definitely.
Yeah.
Quick on the order for my seating.
Your Honor, I wanted to preempt something for you. The state did have a somewhat special request. The Duffy family has Ms. Garrica Duffy on the phone, and she would like to give her victim impact statement via the phone. I believe it is a timed call, because she is still in custody. So if we could begin with the victim impact statements, Your Honor, if the court would, allow us to do that.
Okay. That's not a problem at all. Let's get back on the record in State versus Reynolds. Mr. Reynolds has been brought back out into court. He is still with Mr. Shepard, the jury having found Mr. Reynolds guilty of some but not all counts in the indictment. And we are turning to the sentencing phase. And Mr. Jordan has asked that we take at least some, if not all, we can do it however you want, but at least some of the victim impact statements first before we talk about sentencing and what the structure will be and what the state's recommendation is. So Mr. Jordan, I'll turn it over to you.
Thank you, Your Honor. If at this time we can proceed with a victim impact statement by Ms. Garrica Duffy via the telephone. Your Honor, if we could, we would just place the telephone up here and put the mic towards the phone so the statement can be heard.
However you want to do it.
You can start talking.
Hello.
Yeah, you can do.
Hey, is this Ms. Duffy?
Yes.
Hey, this is Judge McBurney. Mr. Jordan explained to me that you would like to give a victim impact statement now. Has your family told you the result of the trial?
Yes.
Okay, well, I'm ready to hear from you. If you could speak slowly and as clearly as you can so the court reporter can hear you.
Oh, I just want to say it's been a long 7 years that we waited on this day to come, but it was definitely a big impact on my behalf because I lost my daughter at 18 months, and there's a lot of things that we didn't get to do, the mama and daughter days. And I just miss her so much. She's only 18 months, so she only got a chance to do her first birthday and make it to her second birthday. And it's just a lot that we had planned to do as mother and daughter that we didn't get to do. But justice being served is peace to my heart today.
All right, well, I appreciate that. I appreciate your time.
Yes.
Okay, we're gonna talk to you later when you come up.
All right.
Okay.
Okay, thank you.
Thank you, Your Honor. And at this time, Your Honor, the state is going to provide a written statement. If you can place your name into the record.
Okay. My name is Kiana Duffy. I'm Garrica Duffy's sister. And I would just like to make a statement to say that she always just been my little TT, my dress up doll. And I always painted her nails and toes and I did her hair. And I always say, I'm never gonna be able to get to do that with her again.
Thank you, Ms. Duffy.
Good afternoon, Judge. My name is Sharita. I'm Sharita Duffy, Garrica cousin, big cousin. And this is like for the family, the whole family. The action of this defendant has ruined many lives. Our lives will forever be changed. We will never get to see, hug, play with her, or hear her cry again. Mackenzie's mother could not be here today, but she has been truly impacted by the action of this defendant. Mackenzie's mother had to do something no mother should ever have to do. She had to bury her baby girl. We will not be able to see her go to daycare, grade school, or college. Her aunt would never get to hear her say, "My TT." We will never know what her full potential was going to be. Her brother did not have the full opportunity to be a big brother. Our Mackenzie would have been 9 years old this year. We have waited 7 years to receive justice for our Mackenzie. Your Honor, we ask that you impose the maximum sentence under the law, what we was feel to be justice for our Mackenzie. Thank you from Mackenzie Duffy family.
Thank you, Ms. Duffy.
And Your Honor, that does conclude the state's presentation as far as victim impact statements go. Your Honor, there is no aggravating evidence to present as far as criminal history for Mr. Reynolds. Your Honor, a jury of his peers having found Mr. Reynolds guilty of count 2 felony murder, which carries a minimum of life with the possibility of parole and a maximum of life without the possibility of parole. Count 3 felony murder, which also carries the same sentence range. count 5 being cruelty to children in the first degree, and count 6 being aggravated assault. Your Honor, the state's recommendation as to count 2 is life without the possibility of parole. Your Honor, from discussions with defense attorney Mr. Shepard, I do believe that count 3 will vacate as a matter of law. Count 5 would merge into count 2. And count 6, Your Honor, aggravated assault, the state is asking for 20 years to serve to run concurrent with count 2, Your Honor.
You don't think that 6 would merge into 3 and then that pair goes away? I don't know the answer, and I'll research it because I don't want to impose an illegal sentence. There can be only one murder conviction because there's only one victim.
Yes, Your Honor.
And I don't know if the 2 felony murders merge or if one is vacated. I know if Mr. Reynolds had been convicted of malice murder, the 2 felony murders would be vacated. But I thought before they would be vacated, well, no, I guess they get vacated and then the aggravated assault would merge into the malice murder. And so it may be that they're either the cruelty to children or the aggravated assault stays, but it doesn't seem like I should be able to pick which one.
Yeah.
And then it seems random.
I think it's because the count 3 does vacate, Your Honor.
But why would 3 vacate rather than 2? I'm just going to give an example. If trying to think of maybe it would be criminal damage to property in the second degree that has a 5-year maximum rather than a 20. What's the maximum for cruelty to children in the first?
It is 5 to 20, Your Honor.
Okay, so I need to go with my example. Criminal damage to property in the second degree that has a 5-year maximum. Aggravated assault has a 20-year maximum. Should I be able to pick which one merges and doesn't? Because if I'm feeling angry at a defendant, then I'll merge the criminal damage to property, so I have 20 years to work with. But
Your Honor,
I can answer all these questions.
Okay, well, it'll be your turn in a minute. I'm just curious what the state's perspective is.
if it may be safer, Your Honor, I do find that the cruelty to children would be the same activity as the aggravated assault, so it may, as a matter of law, merge into count 5 rather than anything else. But Your Honor, the state's recommendation here is life without the possibility of parole. If count 6 somehow does not merge, we would not ask for that to be consecutive.
Okay, so it's not going to change your recommendation. That would be concurrent if it's still there.
Correct, Your Honor. We do believe that life without the possibility of parole for a crime such as this with an 18-month-old child is an appropriate sentence, Your Honor. And given the wishes of the family who have waited a very, very long time for today, we do join the family in asking for, on the felony murder, the maximum sentence which is allowable by law. And that concludes the state's presentation, Your Honor.
Thank you, Mr. Jordan. Mr. Shepard, I want to hear everything you want to share, but please start with your answer to my confusion about merging and vacating, et cetera.
When you are convicted of malice murder and some felony murders, no matter how many felony murders, assuming it's one victim, then you can't be convicted of murder more than once for the death of one human being.
Right.
So the language that needs to be in the sentences, we used to do appeals on this all the time, and it would get remanded because the judge would say merge instead of vacate by operation of law.
Right.
So you have to sentence on one of the felony murders, and then the other felony murder has to vacate as a matter of law.
Right.
Now, the underlying felony or the felony murder that is not vacated merges. Then the other felony, you have the ability to sentence on that current or consecutive. Now, in the case law, it's very clear that in a case, which is McClellan versus State 274 GA 819, a 2002 case where the judge did exactly what you suggested, but it was rape and burglary. So the defendant enters the home illegally, committing a burglary while inside the house. He rapes and murders the homeowner, female homeowner. And the judge went with felony murder burglary, merged the burglary, and then gave him a sentence on the rape and the murder. And the court said, and I'm just reading from the head note, I'm not going to actually read over the case. When there are 2 felony murders, the trial court must merge only one, the most severe with respect to potential punishment. I
Okay.
believe that in this case, since cruelty to children is
5 to 20.
versus 1 to 20, I mean, we're going to end up in the same spot.
Yep.
But I think that to follow the spirit of the law, that you would want to sentence on felony murder, cruelty to children, because it's 5 to 20.
Yep.
Vacate cruelty to children, ag assault, merge cruelty to children, and then sentence. And we obviously are going to go along with the state on aggravated assault to give 20 to serve concurrent, but we obviously are not asking for without parole. We're asking for life with the possibility of parole, and I have a couple different reasons. One, my client has no felony criminal history. At the time of this event, he was working and he was giving another person rides to work. Obviously, on appeal, we are going to disagree with the jury verdict, but we understand the jury's verdict and we understand the evidence. We're going to always appeal that there was not a sufficiency of evidence and all the other things. But even if you accept the state's version of the case and the jury found that he did not intend to have malice when the baby was beaten. Even if you accept the state's case, there isn't this malice intent, I'm going to kill the baby. They got felony murder on hitting the baby without the malice, the malignant heart. And that even if you accept the state's version, is he struck the baby not with an intent to kill the baby, but in, I guess the best way without having been in the jury room is to say in a fit of rage. And you actually heard state's attorney during her closing, I wish I had her PowerPoint available, that she basically was saying the baby was crying, he was mad at the baby, and he acted out in a way that obviously the jury of the state, he should not have done. But it wasn't like, I'm going to kill a baby. I'm very vicious and I just like killing babies.
Right, or with an instrumentality that is presumptively deadly, shot her in the head. The intent to kill can be derived simply from that act as opposed to a kick or a punch to the ribs.
I had a baseball bat case with Mr. Colley down at Judge Schwartz.
Okay.
In any event, between the fact that one, he has no prior criminal history, he was actually working, paying taxes, paying his bills, helping support his girlfriend's children, and 2, the fact that even under the state's theory of the case, it was just an outburst, a momentary loss of self-control. But more importantly, I always like to say that we have a parole board for a reason, and that we don't have to make the decision about parole today. That we can make the decision about parole in 30 years. And in those 30 years, there'll be plenty of opportunity to evaluate and observe, to see him, to see how he conducts himself while in prison. Is he taking classes? Is he learning a skill? Is he doing things that help other inmates? How is he behaving for 30 years? And then make the decision about whether does this person, who's now 30 years older than he is today, deserve to be released or not be released. And I always feel that a decision of that nature is made better close in time to the release date, not 30 years away.
Right.
And obviously, if Mr. Jordan wants to make a date with me to go over to the parole board in 30 days and have a renewal of this discussion, they could bust me back up from the Villages and I'll meet him over there. We can review. So I just really don't think this is a life without case. And I've sat recently on 2 murder trials where going into sentencing, I knew it was life without. I still asked for life, but I knew I wasn't going to get it. The duct tape case in Douglas County and the hitman for hire case in Gwinnett County. And I knew, and when the judge sentenced to life without, I was, in this case, I just really honestly don't on the inside. And I'm not just saying that because I'm a defense attorney and his attorney, but this is a life on count 2 with the possibility of parole, 20 concurrent on the aggravated assault.
All right.
And I did take the time to refresh my memory on the law for you.
Thank you. I appreciate that. Mr. Reynolds, you have a right to speak if you want to. You don't have to say anything at all. But in the same way that McKinsey's relatives had a right to give a victim impact statement, if there's anything you want to say, you can. But you can also just sit right back down. You're in charge for this moment. Nothing? Okay, thank you. Mr. Reynolds, this case has no good outcomes for anyone. I heard very poignantly from Garrica and her relatives the impact that this has had on the family. It's an impact that will continue. Nothing that we did this week, last week, today will bring Mackenzie back, but in a very, very overdue fashion. The family is at least getting some form of justice for their loss. And there is a belated demonstration that people will sit up and listen and react accordingly when something like this happens, which should never happen. I am taking into consideration in imposing a final sentence, Mr. Reynolds' lack of criminal history. It is all too often that I have someone younger than Mr. Reynolds who has a criminal history that starts from age 11. And has grown and grown and grown and evolved from shoplifting to breaking into cars to armed robbery to finally shooting the victim to take the property. And we don't have anything like that with Mr. Reynolds. That doesn't make less serious what happened, but it provides some important context. Just as important to me is the jury's conclusion as manifested by a not guilty verdict. And keep in mind, that's a unanimous thing. On count one, which is the jury saying that they found that Mr. Reynolds did not intend to kill Mackenzie. And to me, that puts this case in a different category, not in terms of its outcome or the harm or the suffering that the family has gone through. That is present. It doesn't get made better by anything I'm saying here. But that is the jury telling everyone that based on the evidence the state was able to marshal, there was not a finding that Mr. Reynolds meant to kill. He meant to harm, to hurt, to cause pain, but not to kill. And given those two things, no criminal history and the lack of intent to kill, I don't think life without parole is appropriate. I need to keep in mind that I'll be sentencing many cases to come and that I have sentenced many cases in the past. And appropriately, life without parole is limited to situations where everyone pretty easily determines that this is someone who should never, ever, ever again be in circulation in society. And that may be what happens for Mr. Reynolds. This is the possibility of parole. It's not the guarantee of parole. In fact, it's the guarantee that for 30 years, there is no parole. And I think that to Mr. Shepard's point, that is a sufficient period for the Department of Corrections and Pardons and Paroles to be monitoring Mr. Reynolds to see what kind of person he has become, to see if after 30 years it's even appropriate, and they may decide otherwise. And importantly, the Duffy family should know they'll be given a chance to provide input before any decision like that is made 30 years from now. So I'm going to first, I'm going to vacate count 3. There's a not guilty verdict on count 1. Count 2 is guilty. I'm sentencing you to life on count 2. Count 3 is vacated by operation of law. Count 4 was a not guilty verdict. 5 merges with 2. And count 6, aggravated assault, I'm sentencing you to 10 years to serve. That will run consecutive to count 2. And count 7 was a not guilty verdict. So it is a sentence of life plus 10 years. Mr. Reynolds, I need to talk to you a little bit about your appellate rights. You have several, and I'm going to ask Mr. Shepard to help you with that first step, and then he will be allowed to withdraw. So you get an independent lawyer who will be able to evaluate not only mistakes I may have made, but mistakes Mr. Shepard have made. You have the right to what's called a motion for new trial. That would be a motion made here in my courtroom. It would be argued in front of me, and your lawyer would be arguing that I should give you a new trial because of some set of mistakes that occurred. such that the jury's verdict shouldn't stand. If I grant that motion, it gets you a new trial and we do the trial all over again, or the state makes you a new offer and you work your case out. If I deny your motion for new trial, you also have the right to appeal to a higher court. A lawyer would argue many of the same things on your behalf, and an appellate court would consider whether this conviction is valid and whether the sentence is valid. You can do both or just one. You have 30 days from today to file either this placeholder motion for new trial or a notice of appeal. If you don't within 30 days do either of those, you're waiving your appeals and this sentence and this conviction will stand. So I'm going to ask you to talk with Mr. Shepard about whether you want to do the motion for new trial, and if that doesn't work out, the appeal, or if you want to do just the appeal, or if you don't want to do any of those. And Mr. Shepard will, on your behalf, start that process, and he'll be allowed to withdraw, and we'll get another lawyer appointed to you to carry the process forward. You also have a right, independent of whether you seek a motion for new trial or a direct appeal, the right to what's called habeas relief. That's a civil lawsuit that you can bring. You don't have the right to an attorney to help you. You have an attorney. I will always appoint an attorney to help you with your motion for new trial or your direct appeal. But this habeas relief, that's something that if you can hire an attorney, the lawyer can help you, or you can do on your own. But you don't need to worry about habeas until you've exhausted all your appellate rights. When all that's done, you'll still have 4 more years to bring a habeas challenge if that's something you want to do. Mr. Jordan, are there any other appellate rights you think I should cover with Mr. Reynolds?
No, Your Honor.
Mr. Shepard, will you be willing to perform one final task for Mr. Reynolds, and that would be either to file the placeholder motion for new trial or the notice of appeal after the two of you consult?
We've already consulted, and I will be filing a motion for new trial within 30 days of the date of the entry of the sentence with the clerk of the court.
Okay, that'll be today, just so you know, and we'll take it from there.
Fortunately, in criminal cases, if you file it prematurely, it's ripeness. But in a civil case, if you file it early and then don't refile again, that's
Done. Right.
But thank you for going over those rights with my client. I have already covered them. And then after I file the motion for new trial, I will be submitting a motion to withdraw with the court. And then my understanding is the court is going to coordinate with the Fulton County Public Defender or directly with their parent agency, the GPDC, to get a new lawyer.
Exactly.
That would be great.
Okay.
The GPDC doesn't like it.
Okay. Mr. Jordan, anything else for the state?
No, Your Honor.
Mr. Shepard, anything else on behalf of Mr. Reynolds?
No, Your Honor.
All right, we are adjourned. Thank you, everyone.
I'll give possibility, but I've got an extra 10. Well, it's like plus 10, so, but the 10 is on aggravated